Also, may to leave to mention what writ petition can leave granted to move the writ petition day after tomorrow as a mention matter.
Mention matter.
Huh.
Have you filed it?
But today you also can get leave. I can file and move the matter day after tomorrow as a mention matter.
Day after tomorrow. Very well.
Lord, may I permit to mention two matters of Jalpaiguri Circuit Bench. The bench is not sitting in this week. Interim order is going to expire this week, Your Lordship. For this reason, I am mentioning.
Next week I will be there. You mention it there.
Your Lordship, kindly take it.
No, next week it will be there.
May I have Your Lordship, sir?
Brief me here. Brief me here.
Your Lordship, kindly, my lord, to mention item numbers 84 and 93, my lord. But in both matters, my lord, I have challenged, my lord, the issuance of license. My lord, in fact, in 84, the license has not yet been issued. 93, my lord, license has been issued. I will, since license has been issued and he is, my lord, already distributing, so I will not pray for any interim orders. So far as 84 is concerned, my lord, license has not been issued, my lord, and there's, my lord, large scale irregularity, my lord. Some precedence can be given, my lord, because as the lordship has just said, my lordship would be in Jalpaiguri bench next week, my lord. 84, my lord. 84 and 93.
84 and 93.
Yes.
Both the matters.
Yes.
Both license granted.
No matter. In 93 license granted. So I will only pray for my lord direction for filing of affidavits. In 84 my license has not been granted, my lord. Large scale irregularity. Large scale.
So
which I'll show on the face of it.
So 84 is urgent matter.
Yes, my lord. 84 is urgent. Yes, yes, yes.
84 tomorrow mention matter.
Obliged, deeply obliged.
My lord, in urgent matter,
Yes.
I have prepared but not has been affirmed till date.
Which matter?
My lord, one new application, my lord.
Okay.
I would pay for leave, my lord. I just coming and
So what you want?
leave to move day after tomorrow or day after tomorrow.
Day after tomorrow come.
Fine.
Fine.
I see.
Call the list.
And for the petitioner lordship, extension of interim order, your lordship. It is expiring on 30th June. And for the state, my lord. There was a direction.
Affidavit ready?
I'm giving a copy to my learned friend now.
Yes.
May I be permitted to
Let them finish. Yes, whether you shall use affidavit or exception against it,
Lordship? Exception to it?
your matter, whether you will use exception.
Yes, your lordship.
Very well. Please take down.
Like this matter pertains to the vacancy matters, my lord, 2030 control order. May this matter be go out of the list, my lord. My lord has already.
Interim order is there, extending time to time.
Yes. Okay, ma'am.
That is the reason it is appearing.
Yes, my lord.
2013 control order.
Yes, my lord.
Okay. So I am extending the interim order till the disposal.
My lord.
A report in the form of affidavit filed on behalf of respondent number 1 to 5 be taken on record. Full stop. Petitioner is at leave to file exception against the report within 3 weeks from date. Having heard the learned counsel for the parties, considering the matter that in the instant matter 2013 control order is under challenge. Thus, at this juncture, I think it necessary to extend the interim order until further order. Full stop. Now, till disposal of the instant matter. Accordingly, the interim order passed by this court on the earlier occasion is hereby extended till the disposal of this matter. Full stop. Let the matter go out of the list, party is liberty.
Grateful.
Next.
Well, may I be permitted to mention my
Yes.
For extension of the interim order, my lord, the matter was due to appear 3 weeks after vacation, my lord, but the matter has not appeared. My lord, the interim order is going to expire, my lord.
Tomorrow.
My lord, I'm grateful, my lord.
For extension of independent 2013 control order.
2020?
2013 control order.
Okay.
Proceedings, I am appearing for the private respondent. Kindly give me liberty to file the opposition to the.
You have given liberty? No, not.
No, there is no direction to filing affidavit.
No
State,
direction is there.
state,
Direction is upon the state, but he has added as respondent. Right?
Lordship, kindly consider the last order possible of the lordship.
Okay, please take down. This matter appears under the heading of to be mentioned. Under the heading to be mentioned. Full stop. Mr. Devabrata Sarai, learned senior advocate, appearing on behalf of the petitioner. 6 for extension of interim order, which was lastly extended on 6/5/2025.
Hello.
Mr. Dhada, Mr. Ramesh Dhada, learned counsel, appearing on behalf of the added respondent, seeks to file affidavit against the writ petition. Having heard the learned counsel for the parties, the added respondent is leave to file affidavit against the writ petition, affidavit in opposition against the writ petition within 3 weekends. Within 2 weeks, very well, within 2 weeks ends. Full stop. Next para. Interim order passed, no, since no affidavit has been placed by the state respondent, comma, the interim order passed by this court is further extended till 20 August 22nd, 2024. Full stop.
My lord, I'm
Let
grateful.
the matter appear in the list on 30th July. July 30th.
30th July, my lord.
30th July as same position.
30th July.
As same position.
Yes. Next.
But may I pray, my lord, one indulgence, but I'm sorry,
Yes,
my lord, your
yes.
lordship is pleased to call the list. But item number 17 is fixed at 2 o'clock. Indranil Roy.
Item number
17.
17. Yes.
Indranil Day, I'm sorry.
Indranil Day.
Yes. My lord, I've got a division bench matter, my lord, where my lord, I'm on legs. Could it be, my lord, taken up sometimes next week?
Next week I would not be here.
This সপ্তাহে করবে?
Next week I would not be here. I will Jalpaiguri.
Oh,
Court occasion, my lord.
hey, for the occasion.
Today not possible.
I am always ready. But
My lord, a division bench matter is going on. It will be going on today also, tomorrow also. Could it be, my lord, on Wednesday, 25th?
20.
Wednesday I have several matters.
So this is
Let me
also,
find-
my lord.
Let me find out the Wednesday. That matter is there also, I think.
No. Only notes of parliament. All Bengal.
আচ্ছা
Wednesday?
কালকে But
Carrying forward. Tomorrow.
but is it possible tomorrow, madam?
কালকে কি আছে?
খুব বড় ম্যাটার নয় কিন্তু এটা।
কটা আছে?
তুই যা বলবি।
Already 3 matters fixed. I do not know whether it will be taken up.
Tomorrow not possible, madam.
3 matter already fixed.
TPM one.
3 p.m. 3:30.
Well, because it's not so big matter. I have already concluded my submission.
Yes.
At 3 p.m. it may be
3
concluded.
p.m. or 3:30 or 3:15.
If
Kindly
it is
give it
3
at
p.m. it
3:15.
will be concluded, my lord.
3:15.
My lord.
Well, I'm grateful.
Item number 17,
Yes, my lord.
17. Tomorrow 3 p.m.
Tomorrow
3:15 p.m.
3:50, my lord.
3:15 হবে।
হ্যাঁ,
Item number
আচ্ছা,
17,
দিতে পারবে।
today's list যেটা আছে,
বলে দেন।
3:15. কালকে।
এটা কত বললো?
I'm grateful, man.
20th August.
এই যাত্রাটা কোথায়?
Call next matter.
Your Lordship, I have been instructed by the clerk of Miss Manju Agarwal that she is on the way. Kindly give me a short passover. She is appearing on behalf of the petitioner.
Hmm? Please take down. This matter appears for correction. Full stop. Next para. At the time of passing the order of bail, this court extended petitioner be released on bail upon furnishing PR bond of rupees 10,000. Full stop. It appears that thereafter erroneously 2 registered sureties were directed to furnish the bond. Was directed to furnish the bond by the order of this court. Accordingly, it appears that direction upon sureties it is not required when PR bond is directed to be produced by the petitioner. Thus, I think it necessary to correct necessary portion of the direction of this court at paragraph 10 at page 3 of the impugn order dated of the impugn of order dated May 28, 2025. Next paragraph. In the order dated May 28, 2025, page number 3, comma, paragraph 10 at line 3. The portion of the order read as within inverted comma with 2 registered sureties of like amount each. Close karo. Shall be deleted. Remaining portion of the order would be unemployed.
Original side writ petition.
I am for the petitioner,
Which-
appellate side writ petitioner.
Petition state file affidavit and serve upon
In the original side, who is the learned counsel appearing?
Mr. Sinha and Mr. Sinha and Mr. Chatterjee. They are the affidavit serve upon me. Those kindly give me authority to file the
Where are they? They have not placed that.
optional not submitted before your lordship, but serve upon me.
Okay.
Kindly give me liberty to file the reply to the opposition and fix them. State affidavit are completed.
Mr. Dhara, learned advocate appearing for the petitioner in WPO 104 of 2025 within bracket original site matter bracket closed submits that the state authority has already served him a copy of report or exception report or affidavit report in the form of affidavit. He intends to use exception against the report within a very short span. Full stop. Next part. None appears on behalf of learned state councils appearing in WPO 104 of 2025.
I am for the writ petitioner of appellate side, my lord.
I know that. The learned 104 of 2025. Let the matter appear in the list. 22nd July 2025.
22nd.
Under the same heading. The petitioner of
Next to
WPO 104 of
22nd July.
2025
22nd July.
be at leave to use exception against the report within the urgent.
লিখতে হবে 22nd July, জুন নয়।
Yes. Next.
27, I appear on behalf of
27, my lord. I am for the
Lordship.
petitioner led by Mr. Shukrupokas Lahiri, my lord.
No,
I am praying for only not today.
Your Lordship, there was a direction to pass affidavit in opposition, Your Lordship. I would seek a week's time to file the affidavit, Your Lordship.
I am for the private response.
হরতালে কালকে আমাকে টাইম চাই তো
আমি সেটা বলছিলাম ওই চাই
না না পরের সপ্তাহে থাকছে
An accommodation short for on behalf of the state respondent to file affidavit in opposition. According the matter be adjourned today, lease the matter on 21st July 2025 under the same heading.
21st.
21st.
Yes,
My lord.
May I please your lordship?
Yes.
বেশি করে করো না ছোট করে করো
My lord,
open
a vacancy was published. You should kindly come to page 20, my lord.
Yes.
My lord, kindly come to page 20. And lordship knows, my lord, there are certain conditions which are mandatory to be complied. In that condition, my lord, one is, your lordship kindly come to page 21, my lord. For panchayat area,
Yes.
it must have the space of minimum 300 square feet along with a covered space of 100 square feet adjacent to such and such. And it should be not exceed 3 compartments. I said, so my lord, I have got this all. Then my lord, its a plinth level should be 1 foot from road level.
Yes.
And godown should be a ready godown. And having roof made of concrete slab. So lordship kindly mark roof made of concrete slab. That is B. Has your lordship got, my lord?
Yes.
Then my lord will kindly come to page 24. I have applied on 25th July 2024. Now a godown sketch is at page 26, my lord. Page 27.
Your go down.
My lord, my godown.
Yes.
My lord, you are seeing First compartment 27 by 10, 270 square feet. Second compartment 10 by 13, 130 square feet. So my godown is 400 square feet and my office is 13 into 8, 104 square feet. Now, my lord, it is fortified by the inquiry report, my lord, that is at page 56. 56 is the notice, 57 is the inquiry report. The minor deviation is there. My lord,
Yes.
serial 4, dimension of godown 12.83, 9.5, and I have shown it 13.10, 13 into 10. Then minor deviation, madam. And 27 by 10, they have shown 25.5 and 10.4. Somewhere it is less, somewhere it is more. And then, my lord, the length and breadth, now the office. And now, my lord, kindly come to serial 10. Status of the roof of the godown is concrete. Status of floor of the godown cemented. 14, character of the land vastu. Now, my lord, bank balance, that is 62,646. That is at 15. Then, my lord, you can see 22. Distance of shop come around 600 meters.
Yes.
So, my lord, in all way, I am competent and entitled to get this dealership. What has happened, my lord, that only to accommodate the second candidate, they have made re-inquiry. And upon re-inquiry, when his godown was not completed the first inquiry, his inquiry was done again and he was put in serial number 1. Though his godown is having asbestos sheet, not concrete roof, but still he is doing it. My lord, kindly come to paragraph. My allegation, my lord, is that my lord, 10, paragraph 10. Subsequently, the petitioner came to know that the spot number 5 has been selected for the dealership despite fact that his godown was incomplete on the date of first inquiry and the petitioner's application has been rejected. And upon such information, the petitioner searched in the portal and found his rejection therein. That rejection portal is, my lord, at last page at page 60. My rejection without disclosing any reason. Last page, my lord, page 60.
Yes.
My name is HON'BLE, that is at page 60, and rejected. No reason why it has been rejected. Then, my lord, you kindly see paragraph 15 of the. My lord, my shop godown is 600 meters according to their own report. And the petitioner has been, I have stated, my lord, on oath, that the petitioner has been able to gather that the godown of the spot number 5 is not only 1.3 kilometers far from the advertised location, but also situated at 2.5 feet low from the level of main road with construction of tin roof. And not having sufficient space for parking a vehicle to unload the materials, but all the said conditions have been relaxed by the authority only to favor him. Why this is a particular allegation against the authorities for giving relaxation to the respondent number 5. My lord, my lord, I am praying for let them submit a report along with all the inquiry reports. And my lord, in the meantime, not to take any further step. Whatever step has been taken, but no further steps will be taken.
Now, what is the status now? What is the status?
Only they have been selected. Nothing, my lord, there. No more.
Yes.
May I just indicate?
Yes.
Well, so for the status of the case, I am really handicapped to inform this court. What I'm either lordship takes it up tomorrow, I can inform the court what is the status, or your lordship, since your lordship will not be available from the next week, I have heard. Milord, I will file an affidavit subject to the abide of the interim order which my learned friend is seeking. Instead of that, what I'm proposing, the result would be subject to the abide by the writ petition. This much can be done. If your lordship finds there is arbitrariness, then your lordship can pass an order.
No, the
Two things I would like to point it out.
allegations is, otherwise, everything is correct, but the situation that the plinth level is low.
I just
The
pointed out.
Otherwise,
this-
Tin said
no,
is
no, that is
applicable,
all right.
everything applicable.
Lordship may recall in the Enterprise, this matter came up for consideration for your lordship. The length was little low and the inquiry was held. Lordship was set aside that order. That matter went up to the appeal. Lordship knows
Not only that ground, other grounds also.
other ground is also there. So the learned division bench held, no, this is not correct, because whatever we are basically asking for, we are the tender calling authority. Lordship knows the judgment, Ramanna Dayaram Sethi.
Yes.
We are bound by that conditions. Whatever we are seeking, we have to go by that. But there is no question of favoring. The paragraph 10, which my learned friend has relied upon, this is a mere allegations only. This is a statement, I would say, with no substance. So, Millard, let me file an affidavit today. I will come back. Subject to the result of the writ petition, Lordship may pass the necessary order.
My lord, if only selection has been done, I want to stand in the way if the license has been granted. I want to stand in the way. Your lordship can clarify that if the license is granted, your lordship will not pass any. That interval will not be effective. But if license,
That I want to know whether the license.
That is what I am saying.
No, my lord.
Millard, I have a full faith on Mr. Agarwal, because Mr. Agarwal have the better knowledge than of me.
No, no,
Because
Then come on tomorrow with a report.
yes, no problem. I will come
on
back.
tomorrow.
I will
If
come back.
license is granted, then the otherwise, and the license not
Well,
granted, I will pass.
Can
the
it be
report.
day after tomorrow?
Day after
or-
tomorrow, not
Oh, your lordship will not be.
Yes.
Oh, yes.
Come on tomorrow.
Yes,
You
yes, yes.
take the instruction.
Only this much of instruction. What is the status of the same, and I will apprise of this court. Very well, Millard. I will come back.
license দিয়ে দেয়, তাহলে তো status
Tomorrow.
change হয়ে যাবে।
License they will give.
Now not to give a
Same place.
license করে দিলে।
Or at
Same
least
position.
in the course of the day, they should not give any license. That's I expect.
Let me-
because Suman is there. I
Affidavit,
expect to
affidavit,
see this line.
Very well, Millard. I will come back.
Yes.
Lord, your lordship pleasure was that, Lord.
Order. Affidavit of service filed on behalf of the petitioner is taken on record. Having heard the
Thank
learned
you.
counsel for the parties, let the matter appear tomorrow for providing instruction from the state authority.
My lord, I have paid for dispensation of rule 26 also. Then my lord, that also we can.
appear করেগা যা dispensation কি
The prayer for the
Appear
petitioner
করেগা
for
dispensation.
dispensation.
Private respondents are supposed to be there,
not serve.
because his right would be affected. if
Let me
Yes, I
submit
will
the
come
report.
93 কিন্তু সাহেব বললেন না।
For dispensation of
29 তো
upon the private respondent is allowed. Next,
Lord, item number 29, Lord, your
29 appear for the petitioner.
your
led by
lordship's
Mr.
pleasure was that, Lord, I should file a report.
yes,
Lord, report is likely to be affirmed on today. Lord, I was indisposed of that, so it has not been settled. Lord, it is to be likely to be affirmed today. Kindly grants me, Lord, 3 or Lord, this week I will serve the report to my learned friend, and you any day in the next week your lordship kindly hears it better, subject to your lordship's convenience.
by the next week you can file it.
In this week I will file it. It is likely to be affirmed on tomorrow or today, my lord.
Lord, I appear for the petitioner led by Mr. Chaudhary in this matter, Lord.
It is likely to be affirmed on
This
today.
should be affirmed. I'll tell you the reason. I'll tell the reason why, my lord. Because all these affidavits, my lord, are to contain reports, my lord, which are already there. Because without those reports, my lord, these notifications could not have been issued. So these are all those are already there. So I don't think they will take much time, Lord. My learned friend is asking for a week's time. Lordship gives them a week's time, my lord.
Today he is going to.
Today
affirm
it
the-
is likely to be affirmed. And tomorrow or day after tomorrow it will be served, my lord. Next week subject to lordship's kind convenience.
Lordship is not there, so Lordship fixes it, my lord, after Lordship comes back.
You,
In the meantime, my lord, I shall also serve the affidavit reply.
Learned counsel
The
appearing
time
on
to extend the filing of report is
state respondent submits that the report is not ready. So he prayed for extension of time to file report. Having heard the learned counsel, the time for filing affidavit in opposition.
report, not opposition.
Report in the form of affidavit.
Lordship.
Detailed report in the form
Detailed
of
report, yes.
detailed report in the form of affidavit. Be
By Thursday,
extended
Lord? By
for-
Thursday,
extended for a week.
Lordship, Lord.
Extended for a week. The petitioner is leave to use exception against the report within 2 weeks thereafter. Is the matter on 22nd July.
Lordship, Lord.
20
Extremely grateful.
22nd of July.
Yes.
Lord, in Lordship kindly keeps it, my lord, on the day Lordship comes back on Monday, my lord. In the meantime, my lord, we shall serve them in advance. Otherwise, my lord, what happens is, I have not paid for any interim orders. Lord, what can be done is, my lord, they may issue the license, my lord. That's the whole difficulty. Lordship, whenever Lordship will come back after 3 weeks from
No.
today.
Like those matters, other matters are also there. Similar direction is passed in these matters.
Yes, yes, in all the matters, same, my lord, orders can be passed, my lord, that whenever your Lordship comes back, my lord, then otherwise, my Lordship will kindly, my lord, appreciate my predicament, my lord. Once the license is
You
issued, my lord,
mention it on 14. If they file the affidavit or just wait, I have not taken the item number 32. What are you going?
না, এক একটা করে হবে 29 হচ্ছে
You mention it on 14.
on 14th. So Lordship, kindly, my lord, in the order if that's recorded, my lord. That
You
will
can mention it, not necessary to pass. If they file the affidavit and your reply is ready, you can mention it. I shall take your reply and pass.
kindly mentions in the order, my lord. Otherwise, my lord, I know if the determination changes or something or the other happens, my lord, I'll face difficulty because what's there in writing, my lord, will always prevail. That is what I'm on, my lord. And I've faced difficulties earlier.
Petitioner is a leave to mention. Parties are a leave to mention.
Obliged, deeply obliged.
Next.
IPA for the petitioner.
My lord, well, we are in default. The report has not been affirmed. My lord, let there be an extension.
That is a comprehensive report. What I'm
Yes,
asking.
that's not that was the order, but
And I'm not opposing it.
Same issue.
same instrument here.
22nd.
Mr. Dotto, learned senior counsel appearing on behalf of the state submits that the report is not ready. So he pray for extension of time for filing report. Having heard the learned counsel for the petitioner, the time for filing report be extended till further 2 weeks from date. On submission of such report, petitioner is leave to file exception against the report within a week. Let the matter appear in the list on 22nd of July 2025. Petitioner is leave to mention after exchange of affidavits.
Deeply obliged. The IPA for the petitioner. Well, it's same matter. I have not received any report, my lord, as directed by your lordship. But same order may be passed, my lord.
Similar direction. 22nd and liberty to mention after exchange of affidavits.
My lord, I'm filing the report, my lord. As your lordship's direction on the earlier occasion to file comprehensive report, I'm filing the same and serving upon my learned friends. Receive করে রাখো।
Order record with that.
Receive করে দাও না তারপর order। Receive forward করে দাও।
Please take down. Report in the form of affidavit filed on behalf of the respondent number 4 be taken on record. Petitioner is a leave to use exception within 2 weeks from date. Let the matter appear in the list.
Same date may be given, my lord.
22nd.
With liberty, my lord, to mention once the affidavits are complete.
Serve me.
22nd.
My lord, to serve me exception in advance, my lord.
Yes, of course.
Always they shall serve. No issue.
You are Kakuli Noshkar, right?
No, no, I'm Shabnam De Bhatta. My namata nina. Shabnam De. Grateful, Your Lordship.
Same as in 31.
Similar issue.
Yes, yes. Same order as in item number 31 can be passed.
Please check down. যেটা করেছি আগের অর্ডারগুলো 31 দেখেছো? হুম।
Item number 31 টা দেখুন। 31 হয়ে গেছে।
Which matter you are there? 31. No, no, 31 has complete. 33, similar order. 22nd. Liberty to mention. Next.
Same, my lord.
Similar direction. 22nd of July. Liberty to mention.
Item 33.
नाम की देवे।
Where are you? Give your name. Matter shall appear on 22nd. You file affidavit within a week.
Same, my lord. 35.
35 also same.
Lordship.
Similar direction. 22nd, liberty to mention. Who is appearing? Mr. Loskar. Not this week. Next.
Same, my lord. Item number 36, Lordship.
Your Lordship, I'm appearing for the state led by Ms. Sonal Singha.
Item number?
36. Lordship, only today the accommodation.
Why?
36. Lordship, there is one supplementary evidence has to file, Lordship. It will be affirmed by today itself, Lordship, only not today. Item number 36. There are certain urgency, Lordship.
Direction was there to submit a extensive,
Yes, Your Lordship,
extensive
Your
report. So you want to file any supplementary affidavit in this matter?
In item number 36, Lordship, there is a direction to some documents was not filed with the writ petition, Lordship. Subsequently, I have submitted, Lordship was in the view to submit all the
Okay,
documents for
okay,
the
not
proper
today.
adjudication, Lordship.
Item number 36, not today. Code.
Not today. Grateful to that. Grateful.
Next.
Your Lordship, I am appearing for the state led by Ms. Sonal Singha.
Same.
Your Lordship, I am praying for not today.
Same order.
Why not today? Where is the report?
Your Lordship, kindly make it not today.
Not today. You have to submit a report, otherwise the matter will appear on 22nd. You have to submit report within a week. Okay. Submit report within a week, matter shall appear on 22nd. Exception by the petitioner within 2 weeks from date. Liberty to mention.
Same.
Similar.
Similar, my lord.
Similar issue.
38, I'm appearing for the state. I'm being led by Mr. Suman Ghosh. My lord, I'm praying for time to file affidavit in the form of report. 1 week time, my lord.
State.
Okay, file within a week.
My lord.
State has
That shall appear on 22nd of April, 22nd of July. Liberty to mention.
Similar, my lord.
My lord, I am for this state, my lord.
Report?
I am in default.
Within 1 week.
My lord, 10 days.
No,
Yes.
take out a thak.
Let it be there 1 week.
Yes.
Okay.
My lord.
Regular, all
My
orders are there. Similar direction, report within a week. Exception within 2 weeks thereafter. 22nd of July. Liberty to mention.
I beg to have
Similar, my lord.
this one.
Report is ready, Mr. Chatterjee.
Yes, sir.
Ready report?
No. Report is not ready, my lord.
I was surprised.
Because we are testing the division bench orders. But the report is filed before this court is infractious. If the matter is goes
No,
before
one report, one matter report has placed in the list of all the matter within item number 32, I think. The
matter
report
was
has
No,
placed.
this is
That's
not before the
placed.
division bench. This issue is not. No.
This is another matter.
This is another.
Press report. I want a
I-
comprehensive report. File within week.
Lordship.
Similar direction. Report within week. Exception 2 weeks thereafter. 22nd of July. Liberty to mention.
Similar, my lord.
Which for the state? For Jun Roy Mukherjee. They file a report within a week, 22nd of July. Similar direction.
And I am for the petition.
For state, your lordship. Lordship, I'm not having the report with me right now, your lordship.
State challenge the maintainability of the writ petition.
My lord. My lord, this is my application, my lord, whereby, my lord, we have prayed for reading down a provision. On the previous occasion, lordships heard this matter only just for a few minutes, and state also submitted that one judgment they have cited, and questioning the maintainability, though your lordship's observation is in our favor. Lordships asked me why you have filed this petition after a long time. I have submitted before your lordships that at the relevant point of time I was minor and I was not entitled to make
Your father-in-law is running a business. This is the issue. And you challenge that virus.
and lordships kindly see, wait. And lordships kindly see, father-in-law is not been implicated into him. So I prayed before your lordships for read down the provision.
Amendment is there. Their father-in-law is there.
No. The provision, lordships, who will made application, his daughter's spouse is not entitled. I have made application, but my daughter-in-law spouse is not. My father-in-law is not included here. So I submitted before your lordships that it should be read down because this is not.
In the last occasion, your lordship had said,
Challenge the maintainability.
I challenge the maintainability, and nowhere in the petition he has said, because 19(1)(g, right to freedom and trade is there, but 19.6 is also there. Reasonable. So he has to challenge that criteria which has been laid down in 19.6. Nowhere it's there, Your Lordship.
He challenged the
Subject to
viruses,
correction.
I think.
Yes, Your Lordship.
He challenged the viruses, I think.
Yes.
No, I challenge that down.
Read down.
Read down the provision because the provision is not articulate. The provision is not clear. I do not want to challenge the virus because I do not want to abolish the procedure, but I want to read down the language.
Just where interfere with my lord. This point is also covers in a matter which is pending before your lordship, along with other points. Your lordship are here and also passed an interim order. The Advocate General also appeared in that matter. And
No, 24 notification is there.
yes,
This is 13 notification. Control order 2013. No,
I'm extremely sorry. Yes,
But Rijmohan Lal
issue is
issue is same. Rijmohan Lal has been dealt with by your lordship.
there, and we have also challenged the same. Point is
Lordship, sorry, point is same.
And Lordship,
More or less.
Lordship,
More or less.
a preliminary point is that if he's challenging the constitutionality, he has to serve the Advocate General.
Yes.
He's challenging the constitutionality, subject to correction, Your Lordship.
Advocate General get a notice.
No, this writ petition is under Article 226 for reading down the provision.
It's reading down.
Only
then I have
that
no problem.
issue.
If it's reading down, then I have no issues. But
Only
if
reading down, not challenging the viruses of
No,
the
no.
constitutionally of the matter. So what provision you want to crease out?
My
What
lord,
provision? What provision?
my lordship, A, kindly relative includes the family member 1.10. One second. Page 18.9.
Clause 2XA,
My lord.
subclause 2, daughter's spouse.
My lord. Son or daughter. I made application. My lord.
So
My daughter's spouse.
not your daughter's spouse.
My daughter's
What are the meaning of relatives? That is, say, daughter's spouse is also within the relative.
But
son-in-law.
I
So
made
what is your
I
understanding?
made application.
You may be, but you are within the relative.
My
Definition of relative.
my lord, lordship kindly see. My father-in-law is a distributor or dealer.
Very good. So we have to read clause 20, subclause 3A. And small a person holding a license, dealer or distributor or wholesaler in his name, or person whose relative already has a dealer or distributor or wholesaler license. This is the provision.
3A. একদম আগে।
Spousal brother sister. Spousal brother sister যদি
Yes, what is your submission?
Relative includes the family members and the following king, daughter, spouse, son or daughter. Well, I am saying well, that this provision should be read down because it is violation of Article 21 of the Constitution of
No, you
India.
have not challenged. You just want to read down. You
Yes.
want you file the read petition to reading down the provisions. What are the creases? You want to settle it. What you want?
Malad, because Malad, it is firstly Malad, there is a this is not constitutionally legal. There is no.
No, you have not challenged this. You want the
No, that is also
provision.
that is also come under the provision of read down. That is also come under the provision of read down. Lordships kindly see some judgments.
No. If you challenge the constitutional validity, you
I
have
am
to
not
serve.
constitutional validity also whereby this should be read down.
Reading down means you want the order from this court to explanation about the what is the finding, what is the nature, and what is the meaning of the provision. That is
it.
That means you have to consider what are the clause is that. You have to take the clause as it is.
That is
But
one.
if you want to challenge the clause,
That is one of the aspects. And other aspect is, my lord, this is not.
This clause is not constitutionally valid. Then you have to file a separate writ, fresh writ.
My lord, lordships kindly see. First, I want to place some of the book.
No, I understand, but you have not filed any. Read your prayers. You have not challenged the constitutional validity. You just want reading down.
No, I have stated it all my petition, but in reading down provision, there are two aspects. One is constitutional validity, another is reading down. I say this is not constitutional valid, and this should be read down.
Why?
Number
Where
one.
is your pleading?
My pleading is there, madam.
No, there is no such prayer like that.
No, prayer no, but the pleading is there.
Where is your saying that the constitution is not valid?
Madam,
If that be, then you have to serve upon the learned advocate general.
Madam, I have said several paragraphs I have said.
Lordship, kindly look at paragraph 8.
Paragraph? Now that is paragraph 6. Also arbitrary, discriminatory to Article 14 of the Constitution of India.
Paragraph 6.
Page 6.
Very well. Then you serve a learned advocate general. You serve learned advocate general. Please take down. Having heard the learned
only one aspect. If it is finishes, then my lord, I will not go to sharp copy of the advocate general. If I satisfy your lordships, only one book I want to.
No, I understand, but without hearing the advocate general, the matter cannot be heard. You understand the issue. He is not duty bound to submit. The advocate general is the
Lordship,
issue.
subject to correction. From what I gather, he's only praying for reading down.
Yes. No, reading down, not reading down. He asking for pleadings are there, challenging the constitutional validity. I'm making it clear by passing order. Having heard the learned senior advocate appearing on behalf of the petitioner, it appears that though the petitioner has prayed for reading down a particular provisions of WBPDS Control Order 2013, but in pleading, the petitioner actually challenged the violations of the provision of Control Order 2013. It appears that.
Well, I challenge both.
It appears
both
that
way.
the writ petition was not. It appears that to challenge a constitutional validity of a provision of law, the petitioner has to serve upon learned advocate general. In this matter, the advocate general was not served. Accordingly, petitioner is directed to serve learned advocate general in respect of the writ petition along with the annexures thereof. Let the matter appear in the list. July 15, 2025. Under the same heading, the petitioner is directed to file an affidavit of service on the returnable date.
But in the meantime, my lord,
What?
in the meantime, so that this vacancy cannot be filled.
No interim. Next.
Lordship, I am appealing for this report.
The same as item numbers 30, 31. Report file coach?
Report, I am.
The
Yes.
same. Not
What is
ready.
your submission?
Lordship, report is not ready. Please.
Within 1 week,
Lordship.
learned counsel appearing on behalf of the state respondent submits that report seeks accommodation for time to file the report as directed
A
by
detailed report.
file the comprehensive report as directed by this court. Considering the submission, the time for filing the report be further extended for 1 week from date. On submission of such report, petitioner is leave to file exception against the report within 2 weeks thereafter. List the matter on 22nd of July 2025 under the same heading. Petitioner is at leave to mention after exchange of affidavits. After exchange of affidavits.
Your Lordship, I am appealing for the state led by Ms. Sonal Singh. Your Lordship, I am appealing for not today.
Similar.
File report within a week. Comprehensive report. Similar direction.
Similar.
45, I also have to file a exhaustive report in indicating as to
Okay,
why.
come on within a week.
I'm opposing lot for the first time.
Yes, of course, you have a right to do so.
Similar directions. Report within 1 week. Exception within 2 weeks thereafter. It shall appear within
May I pray for,
22nd July.
pray for one indulgence? Let it be for the 2 weeks. I have some difficulty because
It's the same.
কেন বলছি বলতো আমার
সবই similar. তুমি আবার দিন আমার কোনো অসুবিধা নেই। সবই similar. একটা কেন ডিস্টার্ব করছো বলো?
এক উইকসে পারবো না।
15 ম্যাটারে সব শোনো এখানে অলরেডি তোমার কাছে রিপোর্ট আছে।
ঠিক আছে চল ঠিক আছে ও বলছে যখন
I would not be there. You file.
No, I
report
know
in the-
that. I understand. Lordship will not be there.
Yes.
So automatically, I will automatically
fixing
grant
the date
2 weeks
on
time.
22nd of July.
Right.
Okay.
Very well. তাহলে তুমি দিও আমার
ঠিকই আছে তো সে তো থাকবেন ঠিক আছে।
Same.
46, similar direction.
Yes.
22nd July. Liberty to reply.
My lord, in this matter, I am for the state, my lord. My lord, kindly extend the time for filing report, my lord.
Within 1 week?
Yes. Most probably it will be affirmed today.
Very
My lord, my lord, another prayer is there. My lord, previously I mentioned this matter before your lordship for correction of name of the advocate on
In this
21st.
matter?
In this matter, my lord.
This matter?
In this matter. I mentioned it before, and my lord.
And he had informed me also.
Please take down. তাই হবে। Report within 1 week. exception within 2 weeks thereafter আগের অর্ডার করে যা করেছি যে অর্ডার সে একই হ্যাঁ না লাস্টে একটু বলবো তাই লিখছি it shall appear on 22nd July petitioner is at leave to mention after exchange of affidavit হলো এবার next paragraph it appears in the order dated 21/5/2025 that state was represented Mr. Sumon Sengupta, Sambuddha Datta, and Sanatan Panja. The representation of state was made by state on the date was made by Mr. Sopon Kumar Datta, Senior Advocate, AGP, and Mr. Dipankar Dasgupta. The name of advocates appearing in the representation of the state in the order dated 21/5/2025 made erroneously. Let the same be corrected accordingly. তাহলে এটা হবে হচ্ছে স্বপন কুমার দত্ত আর কি এটা করতে এটা কারেকশন করতে অর্ডারই হয়ে গেল নতুন অর্ডারে এই নামটা next
Similar value.
What is the issue of maintainability? Will it will indicate two things I would like to point it out. That the point of maintainability, totaling of the ration cards, the beneficiaries, this has been decided by this court, by Justice Vivek Choudhury. May I just hand it over the judgment of this court?
There was a similar direction. It's same as all the other matters. The direction was to file detailed affidavit in the form of report.
First of all,
let them submit.
First of all, Lordship sees the judgment. আমি তোকে ইয়ে করে পাঠিয়ে দিচ্ছি
তুমি এড্রপ করো পাঠিয়ে দিচ্ছি
ডেট দেয় কোন প্যারাগ্রাফ থেকে জানো
প্রেস করো না প্রত্যেকটা গাইডলাইন নোট এটা রিপ্লাই করো কনক্লুডিং পোর্শন
Now, may I just place the the judgment?
Yes.
But would it be Lordship's convenient to read from this one, or Lordship would take a bigger one? It will be rather.
No, not necessary. I can read.
Very. The notification for appointment of the FPS dealer at such and such dated such and such under Baduria block such and such guidelines dated such and such for the declaration of the new vacancy for appointment of the FPS dealer. The petition carries on business as fair price dealer as Magurai Saptavadi such and such adjacent to the such and such police station, not to be forgotten. In terms of the license grant, judgment of the granted by the license authority as per the provision of the West Bengal public distribution system. Granted by the as per the provision of the West Bengal distribution such and such, a total number of 7535 ration cards are tracked with the petitioner's dealership. The consumer ration cards holders of the Magurai Saptapati are tagged with the petitioner's dealership. On such and such, a vacancy notice of the director of the district distribution, procurement and the supply by order dated such and such was issued for the rationalization of the ration card population. The petitioner challenges this notice of the vacancy. This is where the petitioner is standing. The petitioner states that on such and such, the Additional Secretary Government of West Bengal issued a letter to the Director of the District Distribution Procurement of the Supply regarding the approval for a new vacancy of the FPS dealer in the district North 24 Parganas. The petitioner states that in the said letter dated such and such, there is no proposal for a new vacancy of the fair price dealer at the such and such Baduria block under such and such. Therefore, he argues that the said vacancy notice was issued not only in the violation of the guidelines dated such and such, and the letter dated such and such, but also the said vacancy was not published in the local as well as in a widely circulated daily newspaper, which is essentially required as per the provision of the control order such and such. As such, the said vacancy notice is liable to be cancelled or set aside. Guidelines for nationalization of the ration card population of the notice for the vacancy were published by the Food and Supply Government of West Bengal on respective dates which has been indicated. For the judicious expedition of the matter, the relevant portion of this order must be looked into. The order of such and such government in Food and Supply Department is aware of the fact that the ration card population attached to the existing fair price shops running in the district is not evenly distributed. Some shops are quite overpopulated or varying degrees, whereas some shops are running with the much less population. Naturally, both the beneficiaries and the dealers are being adversely affected in terms of the service through PDS business volume, which is the proportional intact the ration card and the population. In view of the said situation, rationalization of the existing ration card population of the fair price shop of the state has under active consideration of the department of the quite some times past, and the government has decided to nationalize ration cards population registered with the existing FPPS through the setting up in the new FPS or the merger of the ration card with the neighboring FPS as may be convenient to the concerned beneficiaries for the better service to the beneficiaries through the PDS, bringing on the national level of the party in terms of the volume of the business of the amongst of the shops. It is to be kept mind in the exercise the certain range of the ration card population between 6,500 to 7,500 considered to be the minimum average has to be kept ration with the existing FPS while exploring the nationalization population subject to the geographical location and the area and the convenience of the beneficiaries. However, a new FPS now starts with a minimum average population between 4,000 to the 5,000 beneficiary cards. It has to be kept in the mind all categories of the ration cards of the habitant are full and full family shall be tagged or shifted. Following points I will go by that. Following points mentioned below for the guidelines. The following situation may occur considering the rationalization proposal. Situation 1. In case of the overlap FPS having card population more than 12,000, proposal for new vacancy may be given at the appropriate location for the areas under the service of the existing FPS through the bifurcation of the card population as may be convenient to the concerned beneficiaries. Situation 2. In case of the overlap FPS having card population between 10,000 to the 12,000, around 3,000 to 500 card of the existing FPS may be considered for the detagging and be clubbed with the detagged over the populated card of any neighbor FPS for the declaration for suitable new vacancy. The proposal for the same may be given in the location may be convenient for the concerned beneficiaries. The order read as follows. Food and Supply Department has issued guidelines by the memo number such and such dated vacancy of the merger or small ration card population with the neighboring FPS. In the said guidelines, it is emphasized that in case of the excess population, a range between 6,500 and 7,500 ration card beneficiary has to be retained with an existing FPS while exploring such rationalization. However, necessity for further modification of the above range retained population was felt under the active consideration of the department of the sometimes past. Now it has been decided department that a range of such and such ration card will be considered as the average population to be retained with the existing FPS. However, a new FPS may be start within a range of the 3,000 to 4,500. Now kindly skip over the 6. Now kindly come to the 7, paragraph 7. Therefore, from the above order, it can be inferred that via the notification 2021, the minimum average ration card population had to be kept retained with the existing FPS dealer was fixed at 6,500 to 7,500 according to the order of 2022. The minimum average ration card population that had to be kept retained with the existing FPS dealer was fixed at 5,000 to 6,500. Now, according to the vacancy notification 2023, the existing FPS dealer would be allowed to retain less than 5,000 ration card holding population considering the local scenario, convenience, inconvenience of the beneficiaries, and the larger interest of the PTS in the locality. The petitioner in an existing FPS dealer, he stated that the total 7535 number of the consumer ration card holders are presently tagged with the dealership. Therefore, if any appointment is made by following the vacancy notice, that in event the number of the ration card tags with the petitioner dealership would be distractly reduced from the 7535 ration card, which would be the less than the viable limit. Therefore, the said vacancy notice is liable to be cancelled or set aside. The petitioner argues that the said business, even it is not required. Let us
7 and 8 and 9
8
space also only source of life.
Yes. Now, reduce one answer. Then come paragraph 8. The petitioner argues that the said business MRFPS dealers is only the source of the petitioner life and livelihood, which is guaranteed under Article 21 of the Constitution of India. Kindly note, Millard, this is the most important paragraph of this judgment. He has invested huge sums of the money in carrying of the said dealership business, and therefore if the vacancy is filled up in terms of the said vacancy notice and curtail the ration card tagged with the petitioner dealership, then in that event petitioner will suffer irreparable loss and injury which cannot be compensated by any other way, as the viability of this business would be greatly affected. He argues that the respondent issued the impugned notification without following the provision of the control order and existing policy, norms and the procedures of the appointment of a new dealer. Therefore, the said notification is not tenable in the eyes of the law, is glaring example of an arbitrary exercise of the law. He contended that he is the carrying on business on the strictly by following the control order 2013 and distributing MR articles to the consumer tagged with the shop as per the allocation made by the competent authority from time to time. None of the consumer tagged with the petitioner business raised any objection either to the petitioner or competent authority that they are not getting MR articles as per the allocation made by the competent authority, or facing difficulties to get the said articles, or the petitioner is not functioning properly. Therefore, the impugned notification of the vacancy was published without any basis, and for the reason petitioner is praying before this court to issue a writ of mandamus commanding respondent to cancel or resign this, set aside the vacancy notice. After having heard the argument, the learned counsel at length, it is opinion of the court that the respondent have not acted in arbitrary manner while decreasing the ration card holding population to 5,000 for existing FPS dealer. While it is true that the petitioner would have to deal with a lesser number of the population and it could lead to some financial losses, this administrative action does not violate any legal right of the petitioners. While taking the new notification of the vacancy, the Department of the Food and Supply, Government of West Bengal, within their power and authority delegated to them by the state government under the National Food Security Act 2013, the primary object and the expansion of the public distribution systems in India is to provide the necessary consumer food items to subsidized and cheap price, protecting the consumer from the increasing the price of the goods. Therefore, it is in furtherance with the object of the administrative decisions are taken which would benefit the public at large and not just cater interest of a selected few. After introduction of the targeted public distribution system, TDPS in short, the state government has to identify eligible beneficiaries under the National Food Security Act 2013, and this eligible beneficiary would replace the existing set of the beneficiaries and categories under such and such scheme, BPL and others, APL. As a result, this judgment this eligible beneficiary would be tagged with the respective fair price shop where they would get their entitled quantity of the food grains as stipulated under the said act, and therefore there would be a need to be de novo tagging to eligible beneficiaries of the fair price shop, which may be return result to the reduction of the number of the ration cards tagged with the such dealers under NFSA norms. This was published by the Food and Supply Department, Government of West Bengal, by memo such and such. Therefore, following this guideline and the objective, the department issued a notification for vacancy of the subsequent reduction of the number of the ration card population existing FPS dealer. So therefore, I find no merit in the writ petition and dismissed in the same. Milord, the pith and substance of this judgment, it clearly indicates that curtailing of the Milord ration cards is not curtailing his fundamental right. The statute has clearly given the power under clause 9 subsection 6 of the 2015 Act that the state government have a right to control and to manage the beneficiaries, the card and the management. Here also, it is below 5,000. So therefore, today he cannot go on saying that I am holding such and such number of the card. This cannot be cuttled down at my whims and power. Kindly also consider this fact. Today, a person come up by saying, I am holding this much of card. If you cuttle this one, it will be cuttling my fundamental right. Kindly take it from the different angle as well. A person concerned who is eligible, supposed to be, we are giving the everyone a chance to, as per the article 14. I have shown to your lordship in the earlier occasion the article 39B as well as the article 47. The state directive principle. State directive principle is very simple. This has to be maintained, parameters and the equilibrium of the balance is there. Once I have to protect the intoxication, in the other hand, I have to raise the food grains and for the poor people at large. I am asking myself today, by cuttling this or taking this decision, where is the fundamental right of the petitioner is being affected? This has been no more a res integra. This has been decided by this court. Is one more judgment is there, that is Justice Shivkant Prasad. I am empowered with the judgment. If your lordship so desire, I will come back with the judgment. I will show. The first thing is that if there is no fundamental right has been cuttled down or affected, in that event, the mandamus cannot be issued. In that event, the writ petition will fail. This has been already held by this judgment. So, I don't think anything more require after this judgment, and after the judgment of the Shivkant Prasad, I will also show to this judgment.
No, Mr. Sengupta, only one question.
Yes, my lord.
So this is not the prerogative of the state. You know, you call some person to provide them license to distribute the food articles. This is the all purpose.
Correct.
The true purpose is to serve the beneficiaries, to providing them the ration articles.
Correct.
This is the purpose.
Correct.
And state could not undertake by their own department. They use some person.
Agency, yes, correct,
agency.
correct. Yes.
That's why they have used the license.
Correct, correct.
So when you provide them a license,
yes,
to perform a business,
yes,
so there must have some situations that you cannot say them that you engage for 24 hours to serve only 10 persons. This cannot be. You cannot fix such way that he will engage for 24 hours, 7 days, 24 hours, 30 days, and only he would earn an amount that is not viable for his livelihood. That's why there are some provisions in the TPDA that
I believe lordship has seen the clause 9 subsection 6 of the 2015 Acts.
Yes, there are some provisions.
Provision is there. That is why I am saying.
Provision is saying that you must see the business of the person.
Business of a person.
Yes. Rationalization would be there.
Correct. Kindly consider this.
That's why I know that provision. I know the justification.
Lordship is no far better than I do, there is no doubt.
The justification.
Correct.
Justification means detailed justification. I have passed the order. Because whether by such that within 5,000 or 4,000 like that, his business would be viable or not. This is the justification.
Kindly also consider.
I want the justification, what earnings he is.
Correct.
There.
Lordship kindly consider the judgment of the APM, whereby the 2G licensing was going on. Why I am putting myself, why this 2G license was getting cancelled? Because the license Raj, which is basically violating the Article 14. If your lordship kindly see the Article 39B of the Constitution, and if your lordship read the 47 altogether. The state directive principle is very clear, as well as 9.6 একটুখানি বার করে দিত হ্যাঁ ARM-টাতে একটু I just placing this millet ARM judgment once more. এক সেকেন্ড this is the ARM judgment 2011 6 SCC 756. I will not trouble your lordship. I will simply sit here, read Miller the main paragraph চলে যাবে হ্যাঁ করে দিচ্ছি
পড়ার আগে করে দাও
একসাথে করতে গেলে গন্ডগোল হয়ে যাচ্ছে এটাতে না আগে এটা থেকে পড়ে নি হেড নোটস এ পড়ে নি দাঁড়া করে দিচ্ছি আমার এটা থেকে করে দেবে একটুখানি ওইটা দিয়ে আমি বার করে দিচ্ছি ওটা আমারটাতে আছে মানে কাইন্ডলি গিভ মি আ মোমেন্ট মিলে আমি
yes.
লিকুইড টেক্সটটা নেই Millet, I just read Millet this.
Yes.
First, I will read the Millet the head notes of the same. Then I will go by this Millet the penultimate paragraphs. Huh? আচ্ছা ওর মধ্যে আছে দেখ
Yes,
definitely. 2011 6 SCC 756. Eligibility criteria for the participating in the future tender alteration 756. Government policy in respect of the contrary of the provision of the existing contract, scope of the judicial review of in the test of the determine the validity of such policy decision, applicability of the doctrine of the legitimate expectation, if any. Major porters license to operate container terminal on the BOT basis of the period specified containing a provision granting the license liberty to the participating to the subsequent bid for the operation of the development of the consumer terminal license agreement also containing undertaking by licensee to forego its right to bid directly or indirectly for additional facilities or existing facilities in the port area during the such subsequently with the view to promote the healthy facilities in the port area during the said period subsequently with the view to promote healthy competition for benefit of the shipping industry as well as for the Indian port trust. এটা থেকে বার করে দে central government taking competition for the benefit of the shipping industry as well as in the Indian port. Millet, I just indicate what is the fact of the case. Millet, a tender was floated. A successful tenderer was given the chance to operate the same. Subsequently, government has decided that you are enjoying a monopoly things. This should not go on. In this judgment, this has been defined as license raj. Thereby, for the betterment of the same, whether you have a legitimate expectations to continue with the same, that has been dealt with, and says since the government have taken the policy for the betterment of the public at large, this will prevail. This is the Millet the cracks of the judgment. I just indicate Millet the penultimate paragraph. Paragraph 64. Insofar the decision taken by the by the central government to alter its policy regarding the grant of the license, kindly note, alter the policy. There was initially a policy that has been they are altered. And this is the same question coming over here, whether what is fallen from your lordship, whether we can do so or not. Once we have taken the policy decision, whether we can alter the same or not. That is the answer over here. Policy regarding the grant of the license for operating the container terminals in the major ports in the India against the contractual rights embodied in the forms of the clause 2.3 in the agreement executed entered into the between the central government and the appellant and the petitioner in the transferred in the concern. The said controversy is no longer valid in regards to the applicant, since such point has not been taken on behalf of the writ petitioner before the Bombay High Court. However, same has been taken as a writ petition before the however, same has been taken as a specific point on behalf of the petitioner in the transferred case as the tenderer for the second container terminal at the Tuticorin port are concerned. The said question has to be considered in the light of the Article 14 of the Constitution and greater public interest as against the contractual right of the individuals. The provision of the clause 2.3 of the agreement signed between the such and such trust and PCA Silicon cannot be raised isolation of the other provisions of the agreement which prevented the license from the bidding and the other works within the port area during the period of the license. In fact, in our view, changing the relevant portion. Very good. No, এটা অন্যটা।
Okay.
We are in the view the central government was within its power to strike a balance with regards to the control of the port facilities to the same did not come into the concern to the hands of the private group or the consortium which would be in the dominant of the position to control or not only the right of the tariff but also the entry of the ships but not belongs to the such groups into the major ports and thereby giving an undue advantage to its own ship other shipping agencies. Normally, the courts do not interfere with the policy decision of the government unless they are arbitrary or offended or the provision of the Constitution. In the present case, the adoption of such courses would, in our view, be opposite. It has been consistent view of this court that a change of policy by the government can have an overriding effect by the private treaties between the government and a private party. In the same, the general public interest provides such change in the policy guided by the reason several decisions have been cited. The parties in the existence where the such private player would assume a dominant position which would enable them to control not only the bothering ships but the tariff used for the port of the facilities. Kindly Millard, pause here for a moment. This is the same test is going on all over the West Bengal. The person concerned not only getting the benefit from the cardholder, it is also he is depriving the other to participate, Millard, in the process. This is what your lordship has to, Millard, consider. In both cases, under the consideration, the same set of the expenditure and the interested gaining control over the different container themselves to the exclusion of the other players, the central government in the Ministry of the Shipping and the Transport therefore took a decision and to permit the license who has been granted license for the running one of the container terminal breath under the such and such to the bid process and to the immediate next container terminal with the intention the promoting the healthy competition for the benefit of the running on of the bid process immediate next container terminal with the intention the promoting itself competition of the benefit of the shipping industry and the port of the India as well. The decisions to alter the policy is based on the sound reasoning and the central government has taken such decisions for the benefit of the consumer as a whole. The change policy would also have the effect the preventing catalyzation dominant status which would inevitably affect the ultimate pricing consumer goods within the country. Millard, kindly visualize once again. This is the Millard, the license Raj. The government has, Millard, taken a note of the same that no, this cannot be go on. for the greater interest of the public, the other people should also get a chance. Therefore, there is no wrong if I alter the my policy decision. Just yes, just beginning of my argument, Lordship has put a question whether it is justified to give a person to provide the 24 hours service or not. Well, kindly also consider the geographical arena of our state is completely different. Somewhere in the Purulia cannot be considered to the Midnapur or Nadia. This is the beneficial legislation. This legislation has to be done for the benefit of the public at large. This has to be go for the doorsteps or for the poor people at large. This cannot go on or stall at the behest of a person who is already enjoying the benefit out of their business. Now kindly consider the paragraph 70 of this judgment. Although it has been urged by the Mr. Chidambaram, such change policy could be effected only by way of a legislation. Such submission, if accepted, could satisfy the power of the central government to alter the policy to changing the circumstances for the benefit of the public at large. It is not as if the right of the licensee to bid for a further container terminal breadth for the excluded for the entire period for the licensing agreement, but in order to ensure the proper competition and participation by all intending tenderers, the said policy has also been attended to enable such licensee to bid for the next but one tender and when invited. So, Millard, the fundamental right is not being curtailed. We are not taking away all his right. We are not suspending his card. What we are doing? We are keeping the equilibrium of the balance for the beneficial legislation. Keeping না ওটা দেখিয়েছি 17টা দেখো হ্যাঁ 17টাতে প্যারা 10 হুম দাঁড়াও শুনতে যাবো তো হ্যাঁ এটা কি শিবকান্ত প্রসাদের জাজমেন্ট হ্যাঁ হ্যাঁ এটাই yes may I just get back my iPad? I will just handing over one more judgment to your lordship. কোনটাতে এটাতে but that is the consolation. রাজস্থানটা কোথায় গেল এই তো পড়িও রাজস্থানটা দেখি Millard, in my notes there are number of judgment has been Millard quoted. I will just give one after another.
Okay.
May I just get back the Millard the iPad? I will just give in the Millard the one more judgment. এখানেই তো আছে পরপর আগে এটা ওইটা তো well, this is also very important judgment from Rajasthan High Court. This is 2016 to RLW 883. Essential commodity, section 3 and 5, cause of action to file writ petition, guidelines of the state government to ensure that the fair price shop should have 500 cardholder advertisement in inviting offer of the allotment of the new fair price shop, apprehension of the petitioner that if may reduce the number of the ration card attached to their shop, held that the offer has not been finalized nor order any allotment of the fair price shop was passed. Petitioner had not acquired any cause of action to file the writ petition. They have no vested right to insist upon the ration at least 500 card holder for viability of their business. The guidelines would not create any legal rights in their favor. Looking to the geographical condition and the existence of the distribution, the number of the ration card attached to the fire price shop may either exceed or reduce below 500. The authority dealer would have no right to challenge the action. Well, this is at যাচ্ছি দাঁড়া 445. Now kindly see the paragraph 4. Have your lordship got it, Miller?
Yes, yes.
We find the petitioner have not acquired any cause of action to file the writ petition in as much as the advertisement inviting offer for the allotment of the fair price shop were neither finalized nor any order was passed by which the number of the ration cards for the unit attached to them were reduced. In the letter of the Deputy Commissioner of the Deputy Secretary Food and Supply Consumer Affairs Department, Government of Rajasthan, dated such and such, there was a direction to carry out survey on which a new fair price shops may be established, where it has been found number of the ration cards were less than 500. It was directed that the advertisement should be made so that number of the card attached to a fair price shop do not fall below 500 ration cards or 2,000 units. The direction to carry out survey for allotment for new fair price shop in which they should be at least 500 ration card attached to a fair price shop did not in any way violate the petitioner's right, in as much as the object of the public distribution scheme is to ensure the fair and equitable distribution of the scheduled commodities. It is apparent that the petitioner apprehending that the opening of the new fair price shop, the ration card attached to their shop may be reduced, rushed to the court for obtaining relief for which they did not acquire any cause of action. 25 বাবুই হ্যাঁ বললাম তো বলে দিলাম তো 2004 and 5 তো 4 and 5 তো পেজ বলে দিচ্ছি দাঁড়া 883 আরেকটা দেখাই ওইটা কোনটা কোনটা দেখা গৌরচন্দ্রটা এইটা হ্যাঁ Now, Lordship have seen Millard the single bench of our High Court. Lordship has seen the Millard the Supreme Court of the APM. Lordship has seen the Millard the Rajasthan High Court. Now, Millard the another judgment I would like to Millard cited. This is also division bench of our High Court. 2017 SCC Online Cal 5182. এখানেই তো ওটাই তো দেখাচ্ছে তো এইখান থেকে এটাই তো এটা দেখাবো না দাঁড়া দাঁড়া 1 মিনিট দাঁড়া দেখেছি না দরকার নেই ছেড়ে দরকার নেই Millard,
yes,
in the light of this argument which I have tried to advance before your lordship, in fine the pith and substance of the same, that cutting of a Millard the card holder does not affect or doesn't cutting the fundamental right of a MR dealer or the other person. This has been well settled. We are Millard, we are not suspending his card. We are we are doing? We are for the sake of Millard the repetition, I am once again saying we are maintaining the equilibrium of the balance. Well, the Article 14, the essence of the Article 14 has to be taken into the consideration. If today he is asking that my fundamental right has been affected, on the other hand, I would say the fundamental right of the public has been affected if I don't issue this notification. This notification is issuing for the smooth function of the Miller distribution system at large. This notification is not under challenge. This notification allows me to carry on with this Miller, the purpose. Well, the fourth judgment we have cited Miller. It clearly Miller indicates for the purpose of the public interest at large, this can be done.
Okay. Yes, Mr. Huda.
May I just say only one thing? I would, may I just come back tomorrow with a notes of argument and just handing over the judgment with the citations by indicating the relevant portion.
Let him finish.
Yes.
Let him finish.
Yes.
Whether
Today
or tomorrow, whatever maybe he want. So thereafter you file the written notes.
Written notes, because this has to be decided.
Yes.
Direction was only with regard to filing of detailed affidavit. They should have filed it, within. They should have filed it within 2 weeks, of the vacation, They do not do so, Today, they come up and say that we are challenging this on a point of maintainability, when several orders have already been passed, where Mr. Gupta had also appeared, only giving them time, to file the report, what has been, led by Mr. Chaudhary in these matters, the Lordship knows, so that he has to be there, to argue at least, on any issue that they raise, including the point of maintainability as well. Just, to give, briefly,
No, today are you?
No, because they were supposed to file the report,
No, okay. The point of maintainability raised open. They have argued on the point of maintainability. You want to reply on the point of maintainability?
That Mr. Chaudhary will, because
then kindly let Mr. Chaudhary submit. There cannot be a piecemeal argument. My learned friend will make an argument. His senior will come back and make another argument. That is perhaps not proper.
Let's say fix and I believe that they do not want to file any report, and they want to fight it out on the point of maintainability.
No. Already direction is there to submit a report.
Yes.
And it is open that the point of maintainability can be raised.
Yes.
This is the order is there.
At any point of time. Absolutely,
So
absolutely.
They have argued on the point of maintainability. Whether you are ready today to.
So they do not, want to file their report.
That is not the you. I want to hear about on the point of maintainability. What your submission? What they will do, they forget about them.
So Lordship fixes a date, Mr. Chaudhary will come and argue.
Okay, so when? That's why I am.
As it commences to your Lordship.
Comment this week, not possible.
48, 49.
So in any event, there is no interim order, and I've not even prayed for it. So Lordship keeps it when Lordship comes back.
Please take down. Mr. Sumon Sengupta, non-head AGP, appearing on behalf of the state, raise the point of maintainability. It is the submission of the learned counsel appearing at the state that fixing minimum number of DRC population by the DRC population to be retained by a existing FPS dealer by issuing a notification of the government, notification state Karo guideline. So the guideline of the government is not ipso facto violates any fundamental right of licensee. Thus, the instant writ petition is not maintainable. In support of his contention, Mr. Sengupta had cited decisions of this High Court passed in Abdul Khalik Dafadar versus State, also a decision of Honorable Apex Court passed in APM Terminals versus Union of India within bracket 2011 6 SCC 756, and he also cited a decision of Honorable Rajasthan High Court passed in Horiom Meena and others, and another versus State of Rajasthan. Full stop. Mr. Huda, learned counsel appearing on behalf of the
Justice Chaudhury's judgment are also may be deferred. I have cited the Justice
Abdul Khalik Dafadar.
Abdul Khalik Dafadar. Yes, I'm so grateful. No, no, they Joseph lenient.
Okay, কি বললাম? Petitioner intends to argue on reply on point of maintainability and on the latter date. Let the matter appear in the list on July 16, 2025. Hearing on the point of maintainability.
Lordship has kept it on? Lordship keeps it on July 22nd only, my lord. It's been 22nd July.
No, I have fixed it on 16th.
Kindly keeps it on 22nd, my lord. My lord, I know Mr. Chaudhary will be in some difficulty, my lord.
Okay.
Kindly keep it on 22nd.
22nd. July 22nd. Full stop. Petitioner state authority is at leave to file affidavit within as directed above. Within the meantime, reply if any by the petitioner within 1 week after receiving of the affidavit.
2 weeks.
2 weeks after receiving the affidavit. Under the same head.
হ্যাঁ হওয়া উচিত ইয়েস
সবগুলো বলে দেন একসঙ্গে করে দেন
না না আলাদা আলাদা তো আলাদা যেদিন করেছিলাম স্টেটে এসে বলে তুমি কেন
Next.
On a similar, I'm taking a similar point. Maybe it may take it 49.
Item number 49.
Yes.
Similar point of maintainability.
Similar point.
49.
Similar order. Next.
Similar logic. I'm praying for an extension to file the affidavit.
Now, in the matter 49, 48, I have heard the point of maintainability. Whether you want this order, the point of maintainability, so that I
There
can.
also the
Let
point
that
of
be there.
let that be
there.
It has been kept open and the previous order says the same. So let this order also.
Similar order.
Similar order.
Point of maintainability.
Great.
And filing affidavit like that.
I'm praying for extension, my lord. There was a direction to file the.
Which matter? Same matter.
No, no, no. 50. 51 document. अच्छा 52 yes similar.
Same होता ना point of maintainability नहीं है तो. Whether you want the same order.
Let us see what it is.
Okay,
Because
same order.
maintainability for one.
Yes.
Sorry.
53. 53, I'm appearing here. Well, the similar situation. The same orders may be passed.
53, 54 and 55.
I don't know.
Yes, yes. No, 55.
Let me call it. 53 and 54 similar order. Separate order.
Yes, separate order. I'm not seeing.
Next. Mr. Vivekananda Bose. Same order, point of maintainability.
My lord, I am appearing for the state along with Mr. Vivekananda Bose
Okay.
for the state.
22nd of July. You file affidavit within 1 week. Point of maintainability raise open. রাখুন রাখুন
56.
56 was a similar point.
No, my lord, 56 there is another.
My lord, interim order has been refused on 23rd May on the same ground.
Not refused, my lord.
Interim order has been refused.
There is no refusal.
I have on 12:30 matter. You are there 12:30 matter.
Lord, I am raising a
Just
similar
wait,
issue
let
of
me-
maintenance
just 5
on the point of de-tagging and relying on the same set of
My lord,
judgments.
Your Lordship, my lord, in this matter, I have challenged the second vacancy notice since it has been issued in the teeth of the interim order which is already existing. Your Lordship, kindly come to page 27. This is the location Sahapur near Bharat Sevashram Sangh. Has your Lordship got, my lord? Page 27.
Yes.
And this order has been stayed by this honorable court.
Order, where is the order?
Yes, that is page 30. May I read it out, my lord? It will take only 2 minutes, my lord. I am coming to Learned Council appeal we have submitted as follows. My lord, I am not reading this. I am reading Session, sir. In
Not to take further steps in respect of the vacancy notice.
in person of the Therefore, my lord, this vacancy notification has been stayed. Now, my lord, kindly see the vacancy notification at page 37. This interim order was, my lord, extended till disposal of the writ petition. That writ petition is still pending. Now, my lord, kindly come to page 37, same location, near Bharat Sevashram Sangh, Sahapur. But I am asking myself, without leave of the court, whether such vacancy can be declared for the self-same place where the interim order is already existing. That's why I am before Lordship, my lord, that this vacancy notification should be stayed.
May I draw after surveillance?
In a similar circumstance, my lord, there in another matter, a contempt petition was moved. The Lordship knows that in the teeth of the interim order, that vacancy were declared.
May I draw your lordship's kind attention to my lord's order of 23rd May 2025. Similar prayer made, interim order was refused. Your lordship is aware that res judicata operates at different stages of the same proceeding. My learned friend's learned junior had appeared in that matter. Kindly comes to your lordship's order of 23rd May. Similar prayer made, my lord was pleased to consider that on self-same points like in the matters which Mr. Sengupta argued, the de-tagging point was involved under the 2023 control order, whether it could be reduced to less than 5,000. It fell from your lordship because in similar matters, my lord had not passed any interim orders and only called for reports. My lord was pleased not to pass an interim order. So with the deepest of respect to my learned senior friend, perhaps his prayer for interim relief kindly comes to
Yes, Mr. Agarwal, I have already passed an order.
Yes.
That was, my lord, there is no whisper about the earlier interim order, and this has been issued in the teeth of the interim order which is existing. Your lordship was not considered on that day.
No, the issue is that
Your lordship has considered only the issue whether the de-tagging or tagging can be done. My case is that
kindly
in the
comes
teeth
to
of an interim order.
kindly comes to the first page of the order. Submission is perhaps incorrect. Absolutely incorrect submission. Kindly comes to the first page of the order. I do not know what my learned senior friend is arguing over here. Self-same submission made. Self-same submissions.
No.
Kindly sees. My learned senior friend is more articulate than his junior. Kindly seize. Kindly see, the interim order of the court was further affirmed with an order dated 12th October. It is the contention of the petitioner, the state authority, by violating the order of this court, has again issued a new vacancy with a memo number such and such. Self-same petition is scattering. Self-same submissions made by Mr. Agarwal too.
My lord, it was.
My lord
not
has refused the interim order. My lord will tag it with the main matters. I am raising a similar issue of maintainability. This writ petition is not maintainable.
My lord has not considered, my lord, that in the teeth of the interim order, whether this vacancy can be continued. Your lordship will kindly go through your lordship's order. That submission has been recorded, but that has not been considered.
He should have gone up in appeal. My learned should have gone up in appeal. He's
No,
It's
it
not
should be,
my learned friend should not give the
Mr.
sanction.
Agarwal, I have already
I should-
taken your submission on the earlier occasion.
Yes.
But I am of view that the interim order is in respect of vacancy notification.
My lord.
That August vacancy notification.
Yes, and that is for the place.
The August vacancy notification is over. There may be some interim order like that, but new vacancy has come now.
For the self-same place.
No, place is there is no
So
such
that is
interim
the-
order.
What is the order, my lord? Kindly see. Again, the vacancy notification means that the vacancy.
Lord, I'm seriously opposing this submission. But he's stopped from raising this submission.
My lord.
He's stopped from raising this submission.
My
He similar point argued. My lord was pleased not to pass an interim order.
My
He's
lord-
making the self-same argument today.
Okay, Mr. Agarwal. Yes.
Your lordship will kindly consider that, then pass the order, whatever.
No, I have already considered your submission.
In the teeth of the interim order, whether a new vacancy for the same place can.
Let the, I have directed the submit report, let them.
Similar, but I'm raising a similar point of maintainability as argued in item numbers 48. My lord tags it
That is
with those matters.
with regard to the tagging and detagging.
But he should have a right which he can enforce in law. I am saying he has no right which he can enforce in law. It's purely a point of law. He has to overcome that point first. And if your lordship so directs, pending this, I will come back with my report.
Yes.
No, report was already directed, they have not come.
No, Miss Paul has already argued on that point on the earlier occasion, but I have considered her submissions. But I think it necessary to pass the direction to the authority to submit a detailed report.
But they have
regarding
not
justification of the issuing of such.
My lord kindly extends the time by 7 days. I'll come back with the report, and your lordship will be so pleased to tag it with the other batch of matters.
Not my lord, I am not going to be I agree with my learned friend's suggestion that it should be tagged with those matters. Let him give the report. I shall file my exception. This would be heard.
Very well, very well.
But on the point of maintainability, I will be raising a similar issue of maintainability, self-same judgments.
Very good.
I'm grateful.
My lord will kindly record that I have issued my.
Yes. Similar order হবে যেটা হয়েছে interim direction learned senior counsel Mr. Agarwal submits that এটা আগে লিখবে learned senior counsel Mr. Agarwal submits that the state authority had issued a vacancy notification on 16th August 2022 against which the petitioner approached this court via the writ petition number 7792 of 2023, wherein the coordinate bench of this court has directed the state authority not to take further step in respect of the vacancy notification, violating the state order of this court. The impugned
My lord, I am
vacancy
not saying violating, because if say violating, then my lord I will have to go for contempt. I am saying that in the teeth of the interim order.
Okay, in the teeth of the interim order.
Well, that submission was made on the prior date.
Order the new vacancy notification dated
4th
December 2024 was published by the
for the
state
same
over the same area. Mr. Agarwal prayed for an interim order regarding stay of the impugned vacancy notification. Having heard the learned counsel appearing on behalf of the state submits that on the earlier occasion, at the time of admission of the incident writ petition, this argument was advanced by the petitioner, and this court has taken note of the argument of the petitioner by order dated May 23rd 2024, has directed the state authority to file a report. He submits that the report is not yet ready. He seeks 1 week accommodation. Having heard the learned counsel for the party, the state party, it appears to me that the argument advanced by the petitioner has already been considered by this court, and court has directed the authority to file a report. Thus, at this juncture, as the state seeks time to file extension, extension of time to file a report, let the report be placed within a week from date. Reply, if any, by the petitioner against the report be within 2 weeks thereafter. List the matter. The point of mentality list the matter on 22nd.
My lord, on 16th, your lordship, my lord, so coming on 14th.
16th. All the matter I fixed on 22nd.
I am not concerned with those matter, my lord.
Okay, very good. Come on 16.
Under the same heading.
July 16.
Deeply obliged.
Fixed matter, call fixed matter.
I have been briefed in this matter, my lord. And also let the matter be taken up for hearing after a few days.
No, what is the matter? Why it is fixed for 12:30?
Land acquisition matter.
Yes.
In 1968. Thereafter, my lord, the land is lying unused. We asked for that land. That is that matter. So far, yesterday I got this brief. I just had gone. I have told. My learned friend will not made any objection.
No, after hearing the petitioner, I fixed the matter peremptorily till 12:30. That is the
no. On the other day, lordship, I do not know. On the other day, I extend the interim order. It was not known to me that Ami Chilam. The matter was fixed. It was not known to me. However, I have not gone through the order.
Your lordship may fix a hot date because interim order is extended many times to be wrote.
Pleadings complete. Pleadings complete. Pleadings complete. Affidavits or everything complete.
Yes.
Okay.
Let the matter came up for hearing.
Learned counsel appearing on behalf of the petitioner seeks accommodation. According the matter is urgent today. List the matter on July 17, 2025. Under the heading hearing. Full stop. Next para. Interim order passed by this court on the earlier occasion is further extended till July 31st, 2025, or until further order, whichever is urgent.
I'm grateful, my lord.
I fixed on 17.
My lord.
Good. Next week.
After vacation kori na. Next year kore de aro better hai.
Next week means after 2nd week of July. Not this week.
Reply to tab debe na. Exception.
Third, I'm appealing for the petition.
Yes.
Yes. My lord,
What is
I
the
have
matter?
come before your lordship challenging the impugned notice dated 10th June 2025, which is at page 38, annexure P7, my lord. My lord, what happened before taking to the next relevant annexures? I would like to describe the short fact relating to this case, my lord.
Yes.
I am the, my lord, fair price ration shop dealer, my lord. I have been running the fair price ration shop since 2016 after my sad demise of my husband. And thereafter, my lord, in the year 2022, two further ration shop were tagged with me. And before that, my lord, the EPOS machine was introduced. And after introducing the EPOS machine, my lord, I have faced some sort of difficulties regarding the EPOS machine. I have intimated the concerned authorities time and again thereafter. I have been facing some sort of difficulty so that I couldn't be able to upload the data which is necessary for the EPOS machine. And thereafter, my lord,
EPOS machine was defective.
yes.
Okay.
Thereafter, my lord, I have received notice for such not uploading the data in the EPOS machine in 2025 January. I have replied, and thereafter I have been called to attend the hearing. I have attended the hearing. The notice is issued, which is page, if your lordship kindly come at page number 36. This is the notice, first notice.
Yes.
Thereafter, second notice is page 37, my lord.
Notice of personal hearing.
Yes.
Have you attended?
Yes. I have attended. Thereafter, my lord, hearing has been concluded. And despite concluding the hearing, my lord, I was called again through this notice, my lord. That is the impugn notice over here. And my humble submission before your lordship is to quash the second impugn notice and necessary direction be given upon the concerned authorities to repair my EPOS machine so that I could run the rations of smoothly, my lord. This is my humble prayer.
No. In the notice, they have said that there are some shortage of food grains.
Yes, that was happened due to the non.
Reply them.
Yes, I have replied, my lord.
Now you reply the so-called notice. What is the difficulty? They have submitted the inspection report.
I have replied the so-called notice. Thereafter, I have been called to attend the personal hearing. I have attended the personal hearing.
That is in respect of other matter, not the shortage of anything or like that.
No, my lord. It is the same kind of matter. And it is also reflected. You reply dated 19th March 2025 in the case referred above appears not to be satisfactory as it fails to reasonably explain the prima facie contravention of the provision in para 46 of such and such.
No, what is the justification? You just, they have issued you so cause only, not suspended your license or otherwise.
Lordship knows
why you fear? Why you are fear? What's your fear?
Face the
I am ready to face, my lord, because
Then
my,
go
my
there.
difficulty is that I have already attended the hearing for the same purpose.
Have you got entire report, everything?
Not yet, my lord. I have.
Why not? They have inspected your FPS. They have found that there are some shortage of food grains.
The dates are also different. If your lordship kindly take
Yes,
seven
I have
to
seen
see.
that. I have seen that.
Yes, and
The
this is
occasion is
falling
otherwise.
under chapter 9, clause 45, subsection 2. What is
They
the
have not
difficulty?
They have not suspended.
We have just made a so cause. He has to answer to that
You submit
cause.
the notice. You submit the answer.
I have already submitted the answer.
This is the new so cause. This is the new so cause. You have to submit the answer. This is not new so cause, not the earlier hearing like that. This so cause is in respect of the inspection done at your FPS.
And the previous so cause notice and hearing notice, your lordship kindly come.
That is also for a different inspection.
Different inspection.
Inspection was held in respect of my ration shop and the allegations which have been raised against me, and that was basically cleared at the time of hearing. When I have attended the hearing, my lord, I have submitted comprehensive reply over there, and the matter has been concluded. And thereafter,
concluded. Thereafter, they again
another thing has been taken place.
They inspected, so that's why you have to. Then you can satisfy them. Every opportunity we can
Lordship,
satisfy.
grant the sufficient time to reply the same. We will conclude the proceedings.
So what, how many time you require to reply the so-called notice?
A reasonable time may be given, my lord.
What reasonable time I want to know from you?
1 month, my lord.
1 month, 4 weeks. Very well. Please take down.
Millet, kindly also take note. This was the time was given, Millet. Inspection was 23rd May. Have your lordship got it? Then your lordship see, Millet, when we have asked for. During the physical verification, a shortage of such and such, son of such, if they are unable to provide any explanation, according to inquiry report submitted, such and such concerned RPS dealer, beneficiary, a delay after granting the cash memo, which caused inconvenience to the beneficiary. In case the prima facie appears you have been contravened the conditions stipulated in para 16, such and such, you are directed to show cause in writing within 7 days from the date of receipt of this notice. So date of the notice, if I go by that, 10/6/2025.
Yes, I have already mentioned.
Kindly give the 15 days because the allegations are extremely serious.
No, my lord. What happened, my lord? I have already described it, my lord. See, 1 month time is required, my lord. I have already attended the hearing, my lord.
Petitioner is running FPS.
No.
With the license issued by the concerned subdivision controller, Food and Supply, Vishnupur. During running the business, it was noticed by the petitioner that the EPOS machine connected with the FPS of the petitioner running faulty. Reasons thereof, the balance of commodities appearing in the EPOS machine shows incorrect figures. He informed the matter to the concerned subdivisional controller. There was an inspection to the FPS of the petitioner, on the basis of which one so-called notice was served upon the petitioner in the month of March 2025. She was called for in a personal notice for person. He was called for in a personal hearing, where she attended and provided her satisfactory reasons. It is the contents of the petitioner that again one so-called notice was served upon the petitioner by memo dated June 10, 2025, asking the petitioner to submit a show cause within 7 days from the date of receipt of the notice.
Also kindly indicate the allegation. One is the discrepancy of the stock. Second one is the non-issuance of the cash memo.
Yes. Full stop. He submits that the notice issued by the so-called notice issued by the concerned subdivisional controller Food and Supply is illegal. So the same notice is required to be quashed. Full stop. Next para, Mr. Sumon Sengupta, Learned Counsel, appearing on behalf of the petitioner, raised strong objection and submits that according to the provisions of law and under the provisions of para 16 within bracket 9, 45, 46 of the WPDS MNC order 2024, the so-called notice was served. Full stop. He further submits that after inquiry, it appears that there are shortage of food grains in the FPS of the petitioner, as well as the there is also an allegation that the cash memos of the commodities to the beneficiaries were generating in delay. He submits that there are no harm to the petitioner in service of such so-called notice. He prayed for rejection of the instant writ petition. Having heard the learned counsel for the petitioner, it appears to me that the petitioner is running a FPS under the active authority of concerned subdivision controller food and supply. It is within the ambit of the subdivision controller to cause inspection over the FPS of the petitioner. On that behest, the concerned authority had made an inspection at the FPS of the petitioner on 23rd of May 2025, whereby they found some illegalities and served a show-cause notice. Full stop. It further appears that there are some earlier show-cause notice upon the petitioner, wherein the petitioner was replied to the authority. Though the authority has not taken any any decision on the basis of earlier show-cause notice, but that does not refrain the authority concerned to made inspection over the FPS of the petitioner.
Non-functioning of my EPOS machine, my lord.
Just wait.
Yes, ma'am.
Petitioner and to serve show-cause notice. Full stop. Full stop. It further appears that the license of the petitioner was not at all terminated. No card were delinked. Thus, I find the petitioner has not suffered due to the service of such show-cause notice by the concerned authority. However, as the petitioner has approached this court, I like to this court, though I do not find any illegality in the impugned order, but for the purpose of judicious decision of the matter, I think it necessary to pass a direction to the authority to dispose of the show-cause notice according to the law. Accordingly, the instant petition is disposed of, directing the petitioner to submit or reply against the show-cause notice within 3 weeks from date. Full stop. On such reply, the petitioner shall serve with a hearing notice in a particular date that must be within 2 weeks from the date of receiving of the reply, and the decision of the authority thereafter shall be communicated to the petitioner within 2 weeks thereafter. Full stop. I make it clear that the petitioner has made a detailed pleading before this court regarding faulty EPOS machine. The concerned authority shall also consider the issue at the time of hearing.
And I am opposing that since no affidavit has been exchanged, Millet. I am opposing that.
Okay, full stop. I make it clear that this court has not entered into the merit of this matter. All issues are kept open. The concerned subdivision controller shall decision shall pass the written order after hearing the petitioner according to the law without being influenced by any observation of this court. Full stop. Next para. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted.
Obliged, your lordship.
Next.
Nine is my lord. Lordship will kindly recollect this matter. There are 2 content petitions which I had pointed out on the last occasion. I think the other contempt 805 of 2018 is not traceable. तो 5/2018
This is contempt application 68.
68 of 2019.
And I have directed them to tag CP contempt application 805
of
2018 or 15. 2008, what is the number?
One is 68 of 2019, which is today in the list. There is another contempt 805 of 2018. Which Lordship directed to tag with this.
Fifteen actually. No, this is not. It is another matter. No. Number is something different, I think.
But I had today I haven't brought that 805 file, but I had that filing slip. I have that filing slip.
805 of 2015 is placed.
18. 18.
You want 18. I have also passed the order 18. But they are saying no such number is there. No such record is.
I can produce the filing slip.
If you produce a copy of the filing slip, I will place the same. There is report is that there is no such contempt application. Okay, please take down.
I can produce.
It is reported by the assistant registrar, Roman 4 within bracket in charge of concerned department, that there is no case record. No, that they could not trace out the case record of CPAN 805 of 2018, but they have traced out one record, namely CPAN 805 of 2015. Full stop. It appears that CPAN 805 of 2015 is not in connection with the conformity of the instant contempt application. Moreover, the petitioner has not filed the contempt application. Accordingly, the record of CPAN 805 of 2015 be sent down. The petitioner is directed to file a copy of receiving slip of CPAN 805 of 2018 by the next week.
Lordship, I will.
Next.
My lord, this is a new contempt application. My lord,
Another person.
Yes, my lord. Your lordships in this matter already directed, since they have filed one appeal, and in the appeal, my lord, there is no interim order. So, my lord, I am serving your lordship at that contempt. Your lordship directed to file their affidavit in opposition within 2 weeks and 1 week, and matter to appear on 30th July. Let that order be recorded, and I am serving a copy.
No. First you serve them.
Then it will be delayed.
Not delayed. I will take up both the matters also.
So your lordship kindly take it on the next week.
Give me the number.
That number.
Number of the earlier writ petition, earlier contempt application.
What number?
What was the name?
Subroto Notto.
No, he is
Devtosh Notto.
Devtosh Notto. You are?
That is Subroto Notto.
Subroto Notto. Please take down.
Your Lordship, kindly fix the matter next week on Thursday, next Thursday. My lord, in the meantime, I will serve and let them come.
Give me the number. I want to tag both the matters.
Yes.
Instant contempt application was.
But I am giving them. I shall.
Instant contempt application was filed for willful and deliberate, for alleged willful and deliberate violation of the order dated 24/6/2024 passed by this court in WPA 25880 of 2022. Order the learned counsel for the petitioner peruse the impugned order wherein the concerned authority stroke alleged contender was directed to take a written decision within 8 weeks. Having considering the material, considering the impugned order, also considering the submission of the parties, I find there are substance to admit the instant contempt application. Accordingly, the constitutional application be admitted. The petitioner is directed to serve the alleged contender. Full stop. Next, it appears that, and no, learned counsel for the petitioner submits that similar issue was raised in another contempt application being number CPAN. Give me the number.
Yes, madam.
CPAN of 2025. 400. They can have number. We submit that both the matter be taken up together. Having heard the learned counsel for the parties and having heard the learned counsel for the petitioner, let the instant contempt application be tagged with CPN number.
But I am giving the number, my lord, your lordship. I am supply the number to your lordship's court officer. My lord, I shall go and meet.
Let the matter appear 1 week. In a matter appear after 2 weeks. Now, in the second week of July 2025.
July?
Second week of July 2025.
আমি তোমাকে কোথায়
call the list.
Your Lordship, I am appealing for the petitioner, my lord.
I am appearing, my lord, in 61.
I'm led by Mr. Bond. My lord, I'm for the applicant in CAN 1, my lord. I'm praying for not this week, my lord.
What is the CAN 1 for? CAN 1 is an application for addition of party.
My lord, addition of party, we are filing our opposition, my lord.
Have you served?
I have served.
This application is on the face of it not maintainable. My lord, I can show it. This writ petitions has been filed, my lord, challenging my termination order. My lord, the cards, my lord, after my terminations were tagged to this applicant. Now he is coming up with an application for addition of party, my lord, in my writ petitions. My lord, your lordship is well aware of Order 1, Rule 10. My lord, one should be a necessary party or proper party connected with the cause of the writ petitions. But he was a beneficiary of my terminations. Now, for the time being, my lord, my ration cards have been tagged with him. So this is not maintainable, my lord. He cannot have any, my lord, say in my writ petition.
Pursuant
Well,
to the
I can-
order, Lordship, I am filing a report, my lord. Lordship.
Report.
Report.
You serve the copy of the report to Mr. Bandyopadhyay.
My lord, kindly, I'm praying for not this week, my lord.
My lord, I can show 2 judgments, my lord. The copies are there, my lord.
Mr.
One is,
Bandyopadhyay, she is seeking adjournment.
my lord, only problem I am facing, your lordship is well aware, my lord. Before vacations, my lord, I have appeared, my lord. I said that after my terminations, a vacancy has been, my lord, declared, my lord.
in my place, and I had filed an application for stay of that vacancy. That is also pending.
No, report has appeared, so I can hear it out altogether.
Yes, your lordship's pleasure was to hear it out. But in the meantime, if this vacancy is filled up, a third-party interest will be created. My writ petitions will become infructuous. And I can show page by page, this was absolutely a malafide and biased action.
Main matters, my lord, is pleadings are over. Is my lord was fixed on the main matters on the hearing. That will be better, my lord.
But in the meantime, they will appoint a new dealer, in my place, a third-party right will be created.
The petitioners ransack the inquiry.
Yes, I'll show what I have ransacked. I'll show everything.
And the FIR was lodged
A bribe allegations, my lord. I have produced the documents to show that there was a bribe. Demanded by SCFS. I have made the earlier complaint. After my complaint, the show-cause proceeding has been initiated.
Petitioners
and I can show line by line. The persons against whom I made allegations, my lord, he sat judge on my case. But he decided my case. A serious allegations of bribery, demand of bribery. My lord, initially he asked for 50,000. I had paid 25,000. But I failed to pay. Those are all on record.
There is no pleading at all, my lord. That is on the
I'll be showing.
Submission on the
I shall hear it out after returning from Jalpaiguri circuit.
Yes, certain people, you also kindly fix that because it is a somewhat lengthy matter because I need to argue my case.
Okay. So otherwise everything is ready?
Yes, my lord. Pleadings are over.
And only thing, my lord, if you is so pleases, my lord, let them proceed with the vacancy, but not to finalize, because not to create a third party.
That is not the issue of the writ
Your
petition.
lordship
That is the issue of the
that application I have filed.
My lord has and my lord has turned down
that application I had. No turning down, my lord. Your lordship has kept this application pending.
Very good.
What harm would be caused to them? I don't know. It is already temporarily tagged with this applicant. Only for the sake of oppositions, nothing will do.
15 July. 15 July কিছু নেই তো দুটোই কিছু নেই তো Okay, I will dispose of that matter. July 15.
Lordship, around
2 p.m.
Around first week of July.
First week of July, I will not be here. Then you have to go to the Jalpaiguri.
No, it's okay, my lord. Your lordship has fixed 15
First
July.
I am putting on 14. 15 is the 2 p.m. matter. I will dispose of the matter.
Yes.
Please take down.
In the meantime, you lordship kindly direct them not to issue the appointment letter. Let them proceed.
Affidavit in opposition on behalf of the writ petitioner to the application for addition of parties be taken on record. Mr. Amritulal Chatterjee, learned counsel appearing on behalf of the state, submitted a report in pursuance to the direction of this court. Copy served. Let the report be taken on record. Intending intervener seeks accommodation. Accordingly, the matter be adjourned to release the matter peremptorily under the heading of hearing of the entire writ petition along with the application being Can 1 of 2025.
And I have another Can 2 most probably.
Who I have filed, my lord.
Can 2 was already filed.
Can 2 of 2025.
Can
Can 2 and 2025 on July 15, 2025, peremptorily at 2 p.m.
Lordship will kindly record I have filed my affidavit in opposition to their can.
Already recorded.
Already. Come on that date.
Okay.
Before your lordship, Raji, can next matter 62, kindly make it not this thing. Actually, not 62, man.
62, you are for the petitioner? Okay, not this week.
ঠিক আছে
My lord, I'm praying for a leave to file a urgent court application, my lord, and to move on Wednesday, my lord, on 25th.
Okay.
Urgent court application, my lord.
Hmm.
Let it appear as to be mentioned, my lord. To be mentioned.
বুধবার যেগুলো রেখেছি ওগুলো কিসে রেখেছি বুধবার যেগুলো রেখেছি যেগুলো ফাইলে হচ্ছে না ওগুলো কিসে রাখছেন Okay. Call the list. Yes.
Lord, last occasion, Your Lordship, you're submitting with, Your Lordship has opined with regard to the point of law that has been framed by this Honorable Court, and Your Lordship to decide on that particular point. My Lord, I'll be referring to Your Lordship Section 100 of CPC. And
Yes.
I'll be placing, my Lord, certain provisions that subsection 1, 2, 3, and 4. My Lord, what I submitted the last time, Your Lordship, that at the time of admission of appeal under Order 41, Rule 11, my Lord, only one party is being heard, and after hearing, the court frames the point of law. And as per the provisions of Section 104, when Your Lordship is hearing the appeal, Your Lordship to see that whether the point of law that's been framed is correct or not, as per after perusing the records and submissions of the parties.
Yes.
I'll be placing that, Your Lordship, Section 104. 100, Section 100, subsection 4. Second appeal. My Lord, save as otherwise expressly provided in the body of the code or by any other law for the time being in force, an appeal shall lie to the High Court from the first one goes, Your Lordship. Second, an appeal may lie under the sections from an appellate decree. In an appeal under this section, the memorandum appeal shall precisely state the substantial questions of law involved in this appeal. And where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. And my Lord, the last one, I'll be relying on both 4 and 5. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question. So, Your Lordship, the questions that being formulated at the time of hearing, that is not sacrosanct. Your Lordship should see on the basis of the record and submissions of the parties, that the questions being formulated is how far that is. That Your Lordship to decide. And there's a judgment also to that effect. I'll be referring to Your Lordship.
Whether you are arguing that the substantial question of law which was involved, the case does not involve such question.
It's not that. Your Lordship to decide finally. That Your Lordship to decide finally. What I say, what is stated out here, that the appellant will definitely argue on that point. And what the respondent will say, Your Lordship, that it's not correct. My Lord, I'll be referring to a judgment, Your Lordship. It's reported in citation বলছি আমি আপনাকে কপি একটা দিচ্ছি My Lord, on the 5th page, Your Lordship, it deals with second appeal. The provisions being laid down. My Lord, on the very next page. The subsection 1 of section 100 says that the second appeal would be entertained by the High Court only if the High Court is satisfied that the case involves the substantial questions of law. Subsection 3 makes it obligatory upon the appellant to precisely state in memo of appeal the substantial question of law involved in the appeal. Subsection 4 provides that where the High Court is satisfied that any substantial questions of law is involved in the case, it shall formulate that question. In other words, once the High Court is satisfied after hearing the appellant or his counsel, as the case may be, that the appeal involves a substantial question of law, it has to formulate that question and then direct issuance of notice to the respondent of the memo of appeal along with questions of law framed by the High Court. Subsection 5 provides that the appeal shall be heard only on the questions formulated by the High Court under subsection 4. In other words, the jurisdictions of the High Court to decide the second appeal is confined only to the question framed by the High Court under subsection 4. The respondent, however, at the time of hearing of the appeal, is given a right under subsection 5 to raise an objection that the question framed by the High Court under the subsection 4 does not involve in the appeal.
That's why I'm asking whether you are raising such question.
Yes,
That the question which was raised by the division bench
yes,
at the time of formulation of the point of law.
Yes, Lordship.
Whether these are sufficient or you want to formulate some other questions.
We don't want to formulate any other questions, but to your lordships to look into that after perusing the records of the case, whether to see that whether the question being formulated is right or not. Whether the formulation of question has been correctly framed.
No, that is option of the respondent. Respondent after appearance.
That is, we are the
argue
respondent.
that the question which you are framed, that are not sufficient. There are some other questions.
In this matter, we are the respondent before your lordship.
I understand. So I just want to ask you whether, I am asking whether you are not satisfied the questions.
It's not the matter of satisfaction.
Then if the respondent is not satisfied, then the respondent may argue. This is the question. I want you answer from you.
My lord,
what matter you want to enlighten this court?
Your lordship to look into the questions that being formulated, whether that's been correct.
I say look into that is not the issue.
That is it. That's what I was submitting all along, your lordship. I was submitting all along. My lord, your lordship was submitting. Your lordship had inquired.
No, I am there when you are arguing regarding validity of first court. I am saying that no, that validity cannot be looked into the second appeal. There are another order of first appellate court.
Yes, lordship.
So there are some contradictions.
Yes, lordship.
First appellate court and the trial court.
Yes, lordship.
So you have to apprise. That's why the formulation of question by the High Court in second appeal.
Yes, lordship.
These are the provisions.
Yes, lordship.
And if you want to go into the issue in depart, then you have to take recourse under section 103. There are some provisions for the respondent to go into the issue depart.
Yes.
There are some provisions, not to section 105 subsection like that.
Yes.
You read the provisions 103.
Yes, lordship.
There are some provisions where the second appellate court can go deeper into the issues of fact. You see, not in this provision.
No, I have nothing to say wrong. Nothing. It's there.
Okay. Let's proceed.
Yes, lordship. My lord, I'd be further relying upon certain provisions of Indian Easement Act. What I had earlier also submitted before lordship, that after the death of a licensor, once a license is granted, a license could be either implied or expressed. So it could be either in writing or simply verbally. Furthermore, there are other provisions are there also that it could be either any considerations are to be there, license fee, it could be without any fee. My lord, there's only 3-4 provisions are there. The definitions is there, section 52. It speaks of where one person grants to another or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor something which would, in the absence of such right, be unlawful, and such right does not amount to an easement or an interest in the property, the right is called license. My lord, the subsequently, your lordship, section 53, the person who may grant a license, and section 54, it says that grant may be express or implied.
Yes.
Yes. My lord, the learned trial court, your lordship will be kind enough to recall it. The learned trial court has expressed his my lord, things that the court was surprised to the fact that a license was granted without any document. No document been executed, and further that the license, there is no license fee was taken once the license was granted. But that is not compulsory as per the provisions of law.
Very good.
And the other portions is that, your lordship, with regard to license, transferable of license, what I submitted last occasion, my lord, that after the death of any of the party, the license ceased to exist. License there. Section 54 says that unless a different intention is expressed or necessarily implied, a license to attain the place of public entertainment may be transferred by the licensee, but save as aforesaid, a license cannot be transferred by the licensee or exercised by his servant or agent. My lord, so the license is also not transferable. My lord, in our case, your lordship, only two things there. One, my ownership interest over the property. My lord, that is, the trial court has admitted that I am the owner of the property. Owner by purchase, and my name was recorded out there. And my lord, the second portion is granting of license. My lord, granting of license, I have proved to that effect that license was granted. And the father, your lordship, as would be evident from the record, that license was granted by the plaintiff. That is, though, my lord, we had stated that the license was granted in favor of the defendant, but what from the record, it would be evident that the license was prior to such grant, the father of the defendant or the appellant, he was a licensee out there. My lord, even if it is as per the provisions, your lordship, after the death of the father of the defendant, that license ceased. It could have been, my lord, since it is not there, I cannot presume. But admittedly, they have not denied to that effect. First thing, they have not denied to the effect that I am the owner of the property. They have not further denied, your lordship, they have not further denied with regard to the suit property. The suit property which we claimed, the plaintiff respondent has claimed to be the owner of the property. Owner means owning that the defendant has not denied with regard to identification. Which the learned trial court has raised its voice with regard to that the suit property which was purchased by me. It was not the property which I had purchased, was not the suit property.
Yes, anything?
My lord, your lordship would be kind enough to look into it. Effect, although there is no denial to this. My lord, page 13 of my paper book, it has been specifically stated when the court has stated with regard to dealing with the portions of the suit land, the last portions of it says, although there is no denial to the effect from the side of the defendant has not denied with regard to the suit property, that the property which I had been purchased by the plaintiff. And not page 13, your lordship, the second paragraph, the last two lines. Although there is no denial to that effect from the side of the from the side of the defendant. And we had stated, your lordship, we had further submitted with regard to the relationship of the plaintiff and the defendant, and we have nothing more to say, your lordship, to that effect. And my lordship, with regard to, my lord, I'll take your lordship to page 10. the first paragraph, last few lines. It speaks of, this is the finding of the trial court. So from the aforesaid documents and evidence on record, also this court failed to come to a conclusion that the alleged relationship of licensor and licensee was actually existent in between the parties. My lord, this is what I humbly submit before lordship is contrary to record. The record speaks of that the relationship of the plaintiff and the defendant are of license and licensee.
This is your claim. Where is the evidence that there exists licensor and licensee relationship between the plaintiff and the defendant?
My lord, furthermore, your lordship, it's not a tenancy that wherein the relationship.
I am not asking
My
about
lord,
tenancy.
as in the tenancy law, your lordship, you have to prove the relationship between the parties. Out here,
You show me the evidence. Evidence, and this is the observation of the learned trial court. Starting from last paragraph, page 9. You read the entire paragraph.
Yes, your lordship.
This is the understanding of learned trial court.
My lord, my senior friend.
Yes.
Yes, lordship.
So for this court and the issue which has been framed by the division bench in respect of the matter is concerned, where certain question of law has been framed to be decided by the court at the time of disposal of the second appeal under section 100 of the Code of Civil Procedure. Now, my lord, my humble submission before lordship, so far the 5 questions which has been formulated by the division bench. Issue, a suit has been filed against the eviction of a defendant. Suit was filed with a registered deeds in respect of the titles, followed by a notice that has been already, my lord, in the evidence and also in the LCR. Now, not so far the right title interest of the property of anybody's. My lord, sale deed is the one of the important parameters wherefrom it can be decided that the lands or the ownership of the property. Now, my lord, a person, he has been approached a civil court along with his title deeds. My lord, so for the legality and the veracity, whether 68 decimal of land or 25 decimal land or what anything is concerned, whether he's a licensee or not, this is a different issue. I prayed for that I am owner and eviction a particular persons in respect of my premises. Now, the winning of the evidence, so far your lordship's query which is falling from your lordships. I am asking this question to myself. What more evidence has to be placed before lordship for placing his title in respect of before the court below 7 except the title deed? I am asking this question, whether the title deed has been placed before the court? Yes. Before eviction suit, whether the plaintiff complied with the provisions of the law by issuing a notice? My answer is yes. Now, the lower court at the time of adjudications of the title of the property in respect of the plaintiffs, he has not applied his mind. Ultimately, an erroneous order has been passed. Prayer for eviction was simply turned down without recording any reasonable explanation in respect of the ordership. Now, my lord, I am asking this question to myself. The defendants, they are the licensee in respect of a property in the name of their predecessors. The predecessors were expired in the year of 1984. My lord, permissive possession, according to the nomenclature, in respect of the West Bengal Land Storms Act is concerned, the permissive possession or the jongdong, যেটাকে আমরা বলি জবরদখল, or any encroacher, I being the owner of the land, I have to evict him from the premises through eviction suit. I have placed before the court below, but court below, without applying his mind, he pass an order and reject the claim of the petitioner. Now, against that order, we have come before lordships.
No, against that order, appeal has been
before the appellate court. Appellate court, after weighing the evidence, documentary evidence, statement of the PWs and DWs, thereafter, my lord, after applying his judicious mind, pass an order, whereby set aside the order of the court below, or rather I could say, my lord, the reversing the order of the trial court. Against that trial court's order, this instant second appeal come before lordship. To come to the zone of adjudication of this matter within the periphery of the section 100 of the CPC, my lord, I am asking this question to myself. In the four corner of the second appeal, what ground? 7 except the grounds which has been formulated by the division bench at the time of admitting the appeal. This is the first and foremost ground which has been striking your lordship's mind, that the court below erred in law, that without any evidence, reversing the order of the trial courts. According to me, my lord, so for the ground number 1 is concerned. Now, my lord, I am asking this question to myself: what prompted the appellate court to come to a conclusions and taken a decisions and pass an order in favor of the appellant? My lord, four corner of the order, if your lordship take trouble to the my lord, so far the matter is concerned, your lordship study, my lord, carefully, and your lordship gone through the entire records. According to me, my lord, so I have also, my lord, gone through the order, my lord. Evidence, sale deed is there, notice for eviction is there, so for the RS record is there, followed by the correspondence LR record is there. Thereafter, respective parties' deposition is there. Thereafter, the death of the predecessors of the opposite party is there. Now, my lord, what else remains to be adjudicated after perusing all the evidence? Now, another point, perhaps your lordship's mind is striking, my lord, pipendarum of the possibilities why this word has been used by the judges. My lord, when a court, after applying his judicious mind, after applying his mind in respect of the issue and the other thing is concerned, he tried to weighing the evidence. Now, my lord, he finds that the documentary evidence 1, 2, 3, 4, 5 is already there. So for the statements of the PWs and the DWs is there. Thereafter, my lord, he come to a conclusions and opine that the trial court which has been passed is not correct. For that reason, my lord, he reversed the order in favor of the appellant. So for the issue number 1 is concerned. Now, my lord, so for the ground number 2 is concerned, if your lordship take trouble to be the issues which has been framed by the division bench, my lord, LR record of rights or others record is concerned which has been made for whether playing any role in respect of deciding right title interests of a parties. Well, I am asking this question to myself. My lord, here, if your lordship take trouble to the page 45 of the copy of the paper book, your lordship got the?
Yes, proceed.
And on the basis of that, my lord, normally LR record of right doesn't have any, my lord, application of mind with regard to the right title of interest. Now, so for the ground number 2, except 2.
LR ROR and there is ground number 4 is there.
4 and 5.
You read the ground number 4.
But so far 4 is concerned, they try to formulate a question of law with regard to the plaintiff has been able to rebut entries made in the record of rights. My lord, the record of rights made for revision of record of rights made for under section 50 of the West Bengal Landstorms Act. Only for revision of the record of right. Now question comes, what revisions followed? How revision has been made? My lord, the legislator formulate the provisions of the law that if you desire to rebut, updates or mutate your names, there must be some registered instrument. My lord, here I have a sale deed. In RS record of right, 25% there and 75% remaining to us. So whether 25 or 75 or LR, these connectivity with regard to the LR record of right, this is not the case before the court below or in the plaintiff before the suit. Am I clear to lordship?
No, not clear.
My lord, I again just...
Yes, just read question number 4 and answer it. What answer has given by the learned first appellate court?
My lord, again I am repeating.
Yes.
Plaintiff has been able to rebut the entries made RO record of right which stands in the name of defendants. My lord, we made a prayer. That prayer was turned down.
What prayer?
For correction of record of rights.
That was not the issue in the question number 4.
Correct. Now, my lord, here this issue was framed with regard to the relying upon the decisions of the appeal and the trial court. Now, my lord, trial court rejecting the claim of the plaintiff with regard to the suit for declaration or evictions in respect of the defendant parties concerned. There is totally separate issue in respect of the issue number 4 and the order of the tribunal, order of the trial court. If your lordship take trouble to the order of the trial court, just relevant paragraph. Lordship, I think, my lord, that will help in lordship. Apart from aforesaid aspect, I am reading, my lord, page 8.
Yes.
Paragraph number 2, my lord, middle paragraph. Besides the aforesaid aspects, there is no whisper either in plaint or in the examination in chief of PW1 as to whether alleged license has been granted to the defendant in lieu of license fee or not. However, in cross-examinations, PW1 admits that he did not demand any license fee from Bipin for the alleged license. PW1 during testimony never disclosed that he acquaintancy or intimacy with the defendant. So in view of the circumstances, it is very difficult to believe that a parties would grant oral license to another person without any license fee permitting him to reside on his property for a period of 1 year who has no intimacy with him. Apart from aforesaid aspect, it appears from RS Khutian number 125. Well, I'm now coming to your lordship's ground number 4 is concerned. Apart from aforesaid aspects, it appears that from RS Khutian number 125 exhibit B, already in the records, that Bipin Haldar is in a position of 4 annas here. In respect of plot number 477, which covers 60 decimal land in total. From this document can be said well that Bipin was in a position at least 15 decimal of disputed plot in the year of 1954 to 1956 during RS operation. The RS record of right, which finally published settlement record, is strong piece of evidence in respect of possession of Bipin. The plaint as well as the evidence of PW are totally lacking regarding the possession of Bipin in respect of 15 decimal of land of the disputed plot number 477. No document or convincing evidence is appear before this court to rebut this strong piece of evidence toward possession. It is not understand as to why the possession of Bipin in respect to 15 decimal of land is suppressed by the plaintiff. From an evidence that it can be said that the father of the defendant, Bipin, was in possession certain portion of the disputed plots and entire property was not possession of the plaintiff. So, in view of the circumstances, the statement that the defendant, son of Bipin, was granted license in respect of disputed premises in the month of Boishak Taro Bashutti, BS, appears to be totally disbelieved. Besides from exhibit C/2, it appears that possessions of plaintiff was not established and his prayer for rectification was rejected on the ground. So, from this document, as well as from evidence on record, that the court cannot come to a conclusion that relationship of a licensor or license was exist in between the parties as alleged. My lord, in this suit, there is no evidence that at the time of alleged granting of license, possession was delivered by a specific measurement. No evidence is also appeared before this court that the disputed 8 decimal of land as mentioned in the schedule co to the plaint is demarcated and operated from the remaining 52 decimal of land. Moreover, the LR record of right goes show that since 1365, plot number 477 was not in the positions of the original owner, and it is now in possession of the Mrityunjay Haldar, son of late Bipin Haldar. There is no dispute that plaintiff is the owner of the disputed property by purchase. My lord, just for your lordship.
No, you just forget about it. What is your submission regarding item number 4? That is question number 4.
I try to
This is the question whether the plaintiff has been able to rebut the entry made in the record of right, which stands in the name of defendant. This question was raised by the division bench. So, what is your answer about that question?
My lord, a question of law which has been formulated with due respect. Without, I pay my respect to the division bench. Suit for my lord, তফসিল বর্ণিত সম্পত্তি সত্য সাব্যস্ত মতে কায়েম ও চিরস্থায়ী নিষেধাজ্ঞার ডিগ্রি পাইবার প্রার্থনা। দিস ইজ দি সুট। Court can formulate some questions to come to a conclusion so that the matter can be decided. It is not the sacrosanct that the issue which has been formulated by the division bench and that has to be assayed. Court can apply his judicious mind and the discretionary power of the court is much wider. So for your lordship's query, which is following from your lordship, I bow down to lordship's to answer. I tried. What is the plaint?
I know that plaint. What is your submission regarding question number 4?
My lord, question number.
I know the entire matter.
My lord, question number 4. Does it relate to the? Does it relate? Just for my academic discussion.
Yes, I want.
My lord, academic discussion. My lord, does
not
it,
academic. What is your submission?
My lord, this question number 4. I again repeat. Whether the plaintiff has been able to review the entries made in the record of right which stands in the name of defendant.
What is your submission on that?
My lord, so far 25% record which has been appears to be.
You are submitting otherwise. No. Whether plaintiff has claimed any rebuttal of record of right?
Before the BLRO.
Oh, before that? Yes. What are you submitting otherwise? Whether this prayer was made by the plaintiff before the suit? Not there. Whether it is anywhere the case of the plaintiff that record of right is erroneous? Yes or no? Answer me.
Well, my case is not that the.
That's why I'm asking you.
My lord, here, my lord, I just try to assess your lordship. My lord, just one thing. My lord, it is not a case that.
That's why I want to know whether it is a case or not.
No,
so it is not the plaintiff's case.
Lord,
so being a respondent, you are arguing that this point is not required to be dealt with.
Lord,
so this answer I want.
I grateful to lordship, but even then, what?
Next point.
Your lordship, kindly allow me to just one thing. But Lord, this is not a case that RS record was erroneous. For that reason.
That's why I'm asking you this question. What is your submission on that point? But you are not answered.
But Lord,
you have not answered. Very well. Question number 5.
Question number 5. Whether the learned judge in the court below is justified in reversing the judgment and degree of the trial court when the relation of the parties is claimed licensor and licensee if not proved by the plaintiff.
Yes. This is the moot question. Whether learned trial court is justified to decree the suit when admittedly the licensor and licensee relationship between the plaintiff and the defendant has not been proved. This is the justified question. So what is your submission on that point?
Correct. But my answer is very simple. Normally in this plaint, it has been made out by the plaintiff before the court below. That is very close to plaintiff. He has requested him, and on the basis of that understanding, he has been allowed to.
Yes, proceed.
Allowed to stay there. If the lordship kindly take trouble to my plaint.
I know that. You just proceed.
I just. So far, your lordship's query is concerned. Just. প্রতিবাদী খুবই পরিচিত হইতেছেন প্রতিবাদী বসবাস করিতে অসুবিধা হইতে থাকায় 3 আর 4 পাবে প্রতিবাদী তদীয় অসুবিধার কথা উল্লেখ করিয়া বাদী সত্য দখলি বিরোধীয়া তফসিল বর্ণিত 5 গৃহাদি সাময়িক বসবাসের জন্য অনুমতি প্রার্থী হইলে বাদী প্রতিবাদীর অসহায়তার কথা বিবেচনা করিয়া সম্পূর্ণ সহায়তা বশত 1380 সালে বৈশাখ মাসে জমি মায় তদুপরিস্থিত বাদীর প্রস্তুতি ও পাঁচ গৃহাদি প্রতিবাদীকে সাময়িক বসবাসের জন্য মৌখিক অনুমতি প্রদান করে।
This is the pleading. Yes.
My lord, my contention before Lordship, don't take me otherwise. My lord, so for the revisional settlement which has been conducted or operations by the revisional officers in the year of 1956 onward, one aspect, only for collecting revenue of the occupier, not the respective parties. My lord, so for the averment which has been made in the paragraph 4, now how they dealt, whether they have been denied, whether they have been ignored, whether they have been negated. Now your lordship kindly take trouble to the answer. But in the four corner of their WAs, they never denied this contention that the plaintiff allow them, and they have stay there, and they have born there, and ultimately their predecessor BPN was expired on the same time in the year of 1984. Now, according to the LR nomenclature is concerned, my lord, if the permissive possessor was expired, the legal here status is encroaching. So those are residing, rather I could say, my lord, father was licensed and their son.
This is the argument from the bar, not in the pleadings.
But my contention before lordship.
Your contention should be confined in the pleadings. Pleadings, you are saying defendant is the licensee. You have gave the license. Plaintiff said he has given license as he sought for, as you have read it.
Lordship.
But fact shows that the father of the defendant was there.
Lordship.
Since 1955.
Lordship.
This is the case of the defendant.
Correct. Now
our father was there, and we are born there, we are possessing there as a adverse right is accrued. This is the defendant's case, which was not believed by the learned trial court. My question is the issue, point number 4, substantial question of law. Point number 5. What is your answer on that point number 5?
If your lordship take trouble.
When you could not prove the relationship between the licensor and licensee.
My lord, for that reason, I try to take some time, my lord, with regard to the WS is concerned, what they have been.
I have read the WS, what
only
they have said.
I am reading the relevant portions.
I have read the relevant portions.
If your lordship
for a few time, you have also said me on the first day you have read the WS.
My lord, no, that day, my lord, no documentary evidence is here. So for my party is concerned, I am requesting management, then he has given. My lord, if lordship, just relevant portion. Just relevant portion.
You read the pleading, not necessary to read the pleading.
I know, my lord, but just can you allow me relevant portion?
You read
relevant portion, not the whole.
You read the judgment of the learned trial court, it would be sufficient.
My lord, just if your lordship take trouble to the WS, which has been filed by the defendant before the court below.
Yes.
My lord, 5 or 6 pages, not more than that. My lord, kindly just.
You read the page 3 of the
page 3
of the
last paragraph.
Paper book. Page 3 of the paper book. You read page 3 of the paper book.
Well, should I WS?
No, not Bengali. Page 3 of the paper book.
Page 3. The case of the defendant.
Yes.
Paragraph. Number 3. Page 3. The case of the defendant in brief that there is no separate existence core and core schedule mentioned property within the dispute 16 decimal, and the relationship of the license and licensor and licensee was never exist in between the parties. Apart from this, the father of the defendant, namely Bipin, started possession the entire 60 decimal of land since the beginning of 1365 by raising residential construction, kitchen, a privy, and by planting different kinds of trees thereon, and also by excavating ponds as well as rearing fish on the same, and by cultivating the vegetables in the remaining part of the disputed property, and acquire good title by way of adverse possession only, peacefully and knowledge of the plaintiff. Their predecessor, and they said Bipin Haldar, while exercising their possession over the disputed property, died on 25/8/1984. It is further case of the defendant that all the sons and daughters of the were born in the Vita, and their marriage ceremonies were also performed on the same Vita. Bipin Haldar as well as his wife died at the said Vita, and their Sadhu ceremony also performed on the same. It is the entire 60 days covering residential Vita of the Bipin. I think there is certain mistake because 60 decimal, that means 2 bighas of land. And a Vita, I think not 60 decimal, it will be some mistake. Of the the RS record of right in respect of disputed plots under quotidian number 425 stand in the name of Bipin, and LR record of right also stand in the name of defendant. Besides that, decisions of the settlement authority in case of rectifications of the right of WP number 1997 to that effect, possession of the disputed property stand in favor of the defendant. It is further contended that this defendant, since the period of his father, has been possessing the disputed property for more than 30 to 35 years. My lord, here I joining the issue. They have been deposed before the court, and court come to a conclusion that they are in possession of 30 to 35 years. Taken into consideration of this aspect is correct. 30 to 35. Now, my lord, this order was passed. This order was passed in 2001. If your lordship go to the back 30 years, that 65 onwards, not 56 to 65 at the time of RS operation. So, the RS ROR and the depositions and the contention which has been made is totally contradictory. In that event, court can come to a conclusions on the basis of the applying his judicious mind and applying his discretionary power, which is correct or not. But now, I am stressing, my lord, this word. If your lordship take trouble with the page 4, paragraph 4. Your lordship got it?
Yes.
So, the case of the defendant, according to the trial court's order, that they are bank on adverse position. 7 except other, the contention is not the issue before the court. Now, what we have played before the court on the basis of purchase deed, we made an attempt for evict the defendant. Defendant took a plea that we are in adverse position. My lord, may I saying adverse position?
Adverse position was not proved before the learned trial court. They made no appeal. Learned appellate court has also observed that there is no appeal regarding denial of adverse position. So adverse position is now no more. No such ground is exist now.
Just your lordship correct. Your lordship correct. I'm reading. I'm pointing out this word. First paragraph, second, third paragraph. 11 line. By excavating ponds as well as rearing fish on the same, and by cultivating the vegetables in the remaining part of the disputed property, and acquire good title by way of adverse possession.
Adverse possession is now no more. Why are you arguing on that?
No, I'm stressing on the word which has been used by the trial court. I'm not. This is the case of the defendant. It has been made out in the WS as well as the observation of the court.
Yes, trial court did not believe it.
No.
Trial court turned down it. Appellate court has also turned it down. So now adverse possession is no more.
No. Now, if the for abundant precautions, my lord, that a person sought for his right title interest in respect to property.
No, the plaintiff has not filed the suit for right title interest.
No,
he has also prayed for
suit for
eviction of licensees.
My lord, just I'm again repeating the same. Suit for declaration of title, confirming of the position and recovery of khas position.
Yes, recovery of khas position from the licensees.
Declaration of title, confirmation of position. The suit, I mean, if I read সত্য সাব্যস্ত মতে
confirmation of possession.
Confirmation of possession. Now, my lord, suit for declaration of title on the basis of registered deeds and confirmation of the possession, 2 part, and 3rd part, which is very important now, my lord, recovery of the khas possessions from the defendant.
So confirmation of possession can be only given if recovery of khas possession is made. This is the matter. So declaration of title and eviction of the licensees from the suit premises and giving the possession. This is the suit altogether.
Three small spaces or nomenclature which has been made for the suits. Now, the right title part has been denied by the court below. Trial court, it did not consider. And appeal court rightly observed on the basis of sale deed the right title interest in favor of the appellant.
Very good. That is there. But what is your answer about question number 5? That's why I want to know. What is your answer?
My lord, so for the question number 5, again I repeating so that I can assist your lordship for answering my queries. Lordship. Here, one Bengali proverb is there, Lordship. One Bengali proverb is there, Lordship, that Lordship, কারো দুঃখ দেখে, one Bengali proverb is কারো দুঃখ দেখে কাউকে সাহায্য করতে নেই. So here, the defendant sought for accommodations from the plaintiffs. Normally in rural village, it has been requested and on the basis of that it has been accepted. And the averment of paragraph 4 of my plaint, the same contention has been made 4 corner of the plaint. I could have been understood that there is some written, there is something which can be shown before the court.
Yes, it has shown that your averment in paragraph 4 is not correct. They have said they never receive any license like that.
I'm coming.
This is the defendant case.
What is the averment of my paragraph court which has been dealt with by the other side. For that reason, I am relying the WS which has been filed by Malan Friend. If your lordship, because the issue is very simple. Whether the trial court's order reversing the appellate court in absence of any license is correct or not? In absence of
In
any
absence of a
license.
relationship between licensor and licensee.
I'm owner, I'm a licensor, and the defendant is a licensee.
So show me the evidence or any document that the license or the trial court, whether there is any evidence that the license has been given to the defendant by the plaintiff.
In the plaint, it has not been mentioned any four corner of the order.
Plaint was mentioned, but it was denied by the defendant. So you have to prove it. You have to corroborate. Yes.
No, where from your lordship observe that is denied? In the RS, they have not denied.
Not RS. They are saying.
No.
They are saying.
In the WS, they have not been denied.
Yes, denied. Yes. They have denied that they never received license from you. What you have read in the WS?
We have allowed them to stay here.
Whether they have admitted it? They have never admitted it.
Well, then I have to given the relevant paragraph.
Yes.
Yes.
They have said the Bipin, that is their father was there. Since then they are staying there. This is the only case where they admitted that you have given them license.
Oh. No, I am not said so. What I am trying to assess your lordship that in normal practice and procedure in rural village, that if you will allow me to stay for the time being, then I shall.
These are the for submissions. Now we are not in the submissions. We have some observations. We have to evaluate the observations.
I tried it.
Yes.
I tried. My lord, if your lordship take trouble to thee,
Are you not ready today?
well, I think, my lord, so far your question is concerned, my lord.
Question is already there. I am not concerned.
So far your lordship's query is concerned.
Yes, query on the point of law which was framed by the Honorable Division Bench. I have to deal with that in the second appeal.
Lord, I have to again check mine. Because so far your lordship query is very pertinent to be decided this issue with regard to the present second appeal is concerned. So if your lordship kindly just for my personal
from the day one, this is my question.
Okay, I shall try my level best. A very shortest date, convenient date, so the matter can be hardened. The query is very pertinent. I shall try to assist the lordship. Because evidence on my part.
You find out there is, and is there any evidence regarding their admission of giving license? There is no such documentary or oral evidence on that point. There is no such oral.
Hope for the best.
Not hope for the best. This is the document which was placed before me. I have gone through all entire evidence.
So far my side is concerned, I try my level best to be assist your lordship so that your lordship can pass elaborate decisions on that issue. And after helping your lordship for deciding this issue.
Very good.
So far the evidence is concerned, I try my level.
Then I conclude your submissions today.
No, my lord, only one day, maybe any illness.
If you want me to decide the issue on the point of law or on the point of evidence on
No, your
record,
lordship can decide. Your
I can
lordship-
decide. Or otherwise, if you want to impress this court on that point, I can give you an opportunity.
Your lordship can.
So what you want?
If your lordship give me opportunity.
Very good. Argument on behalf of the respondent continues. Let the matter appear in the list. Seventeenth at 12:30. July 17, 12:30.
My lord, then it will be extended till that.
When how?
Interim order stayed.
Your application is pending because your lordship desire was that both the matter should be taken up.
Interim order passed by this court on the earlier occasion is extended till the urgent date. Call the next matter.
এই কবে দিল 17 পরের মাসে 17 এই পরের মাসে 17 পরের মাসে
Sorry, sir. Oh, nothing. না না ঠিক আছে Yes.
So learned Advocate General has raised only question
As regard to the
as regard to the alternative remedy is there.
Yes.
So arbitration clause as 89 is there. So whether this court can proceed.
Yes.
This is the only issue.
formulated this 3-point, my lord.
He has not dealt with any other issue. You have
No,
argued.
no, my lord. That the
No issue.
arbitrations clause content in the agreement.
Yes.
So therefore, the alternative remedy is available to the petitioners. So without exhausting the alternative remedy, my lord, that the writ jurisdictions
Yes.
cannot be invoked.
This is the only
Number
sum.
one. Number two, initiations of inquiry and impositions of penalty is not violative of fundamental right.
Yes.
And the third, my lord, no case of without jurisdictions has been made out. This 3-point, my lord, as I have taken note of, my lord.
Yes, yes.
So for the, my lord, first question, my lord, first issues, my lord, that the whether the writ petitions could be invoked, my lord, and in the presence of an arbitrations clause in the contract, my lord. This has already been decided by the Supreme Court, a catena of decisions, my lords. The decisions which was cited by my learned friend, my lord, even, my lord, in that decisions, I have distinguished that decisions, even in that decisions also, Supreme Court says generally, writ court will not entertain writ petitions, my lord. So generally means, my lord, there are other, my lord, the special circumstances, my lord. That special circumstances has been called out, my lord, by the Supreme Court in a catena of decisions right from the Whirlpool's case and prior to that in 1983 Lotus Hotels case,
Yes.
my lord. Then 2001 Whirlpool's case, thereafter AB Internationals, all 6 judgment I have cited, my lord. Out of them, my lord, 6 judgment I have cited, my lord, where, my lord, even in the field of contract, my lord, that the writ court is well empowered, my lord, to invoke the writ jurisdictions if there is any violations of fundamental right, my lord.
Yes.
Or, my lord, that the actions is taken by the authorities is completely without jurisdiction, or, my lord, if the violence of the act is challenged. These are the 3 specified circumstances, my lord, and that which was called out in, my lord, Whirlpool's case, my lord, the same findings, my lord, is followed, my lord, that has not been, my lord, and otherwise, my lord, second, my lord, by the Supreme Court and still hold the field, my lord. So on this point, my lord. And the second questions, my lord, that then another questions was raised by the learned Advocate General, that since 2 report has come to surface before this honorable court,
one report was submitted by the department and another report obtained by the petitioners. So this is also my learned advocate general has not been properly instructed. In the facts of the case is this, my lord, that my lord, two reports, my lord, was prepared, my lord, by the government department itself, my lord. What happened, my lord, when my lord, the first report, my lord, was prepared, my lord, then on receipt of the report, petitioners made a representations, my lord, that the somewhat this has not been properly, my lord, tested, my lord. So retesting could be done, my lord. Then accordingly, my lord, that the retesting was carried on, my lord, and then it was found, my lord, that the within the prescribed parameters of the, my lord, percentage of moistures, my lord. So therefore, my lord, the submissions that the two different reports because placed before the court, so therefore, as to the genuineness of the report is questioned, my lord, and to decide that evidence is required to be gone into. This is not the correct state of facts, my lord. Both the reports are admitted, my lord, because in first occasions, my lord, it was tested, my lord, and found, my lord, it is, my lord, above the, my lord, prescribed parameter. Though, my lord, according to us, my lord, that the statute says that prescribed parameter is 0.5, my lord, but they have prescribed in the context 0.1. So that is one aspect. And the
learned advocate general has argued that the report, first report, was made by the government department. Thereafter, the second report, which you placed, that is the report filed by other department, which was not recognized.
No, this is not the case, my lord. This is not the case, my lord. Same authority, my lord. What happened, my lord? When, my lord?
Sorry to interrupt. The learned advocate general specifically pointed out that as per the agreement as well as from the tender document, it is only the quality control department of the food and supply
Which can
only authorized to measure the quantity or parameters as contemplated in the agreement.
Yes.
Now, the report that has been relied upon my learned senior friend, that was from outsider, and there was a measure how the samples should be drawn and it would be sent to laboratory for testing.
This is the
that was not been done, and this is not the admitted. The subsequent report that is not the admitted.
This is not the correct state of facts. I invite your lordship's attention, my lord. This is not the correct state of facts. সম্ভবত রিপোর্ট গুলো বার করো টেস্টিং রিপোর্ট না না এক মিনিট স্যাম্পল রিটেস্টিং গুলো দাদা না রিটেস্টিং রিপোর্ট দাদা তো এইভাবে তৈরি হয়ে আসেনি 134 এটা হচ্ছে ইন রেসপেক্ট অফ বার্ড 1 1 No, resampling. Milord, I invite your lordship's attention, Milord, at page 132.
Page 132.
132. This is one instance, Milord. That analytical report of sugar resampling at page 132.
Yes.
IMQC department. That was done by the chemist in inspections of quality control. Same authority, Milord. Retesting, Milord, your lordship says resampling, analytical report of sugar resampling. Your lordship got it?
Yes.
And Milord, that is found to be within the parameter moisture content 0.1. And then Milord 136. Again, Milord 136, joint resampling at page 136. Moisture content 0.1. Same quality control. Not other department. Then 137 and 138. At page 137, sampling, Milord, and the next, Milord, the resampling, Milord. Next page, 138. 137 and 138. Moisture content 0.12, 0.10. Well within the parameter. After retesting. And Milord, after retesting, when it was found, Milord, that all the lot of the sugar, Milord, were within the parameters, Milord, allowed to distribute those sugars, Milord, and that was distributed, Milord, to the end user, Milord. And so there was no loss, Milord, on the part of the government, Milord. Still, Milord, the government imposed penalty, Milord. That is arbitrary, Milord, and that arbitrary actions, Milord, attracts Article 14, Milord, and violative of fundamental rights. And that is why, Milord, that the root jurisdiction is invoked, even in the case, in the field of contract, Milord. In the field of contract, any state actions involves arbitrariness, root jurisdiction would attract, Milord. So these are all on records. What my learned friend is submitting, that the two different people obtained from the two different laboratory, this is absolutely wrong. And he has not been properly instructed, I'm sorry to say.
Yes.
So it is our case, Milord, that we are not disputing the resampling. And on the basis of the resampling, when it was found that it is well within the parameter, they allowed us to distribute the sugar, and we have distributed the sugar throughout the West Bengal to the end user, Milord. So therefore, there was no loss on the part of the government. Still, government imposed penalty. And Milord, on many occasions, Milord, I have, Milord, demonstrated your lordship, Milord, at least in one occasion, Milord, higher quality of sugar was given. Still, show cause notice was issued. And after retesting, it was found that it is a higher quality of sugar. So that's the conduct of the government, Milord. And I argued elaborately on this point, Milord.
Yes.
Then, Milord, so therefore, no question of
Is 31 grade, moisture content 0.09, less than 0.10%. Still does not conform. It is completely contradicted.
Then, Milord, at page 103. What?
Is even their sampling report, they are not 0.9.
Yes, Milord.
And does not conform.
Yes, that I have already demonstrated at page 103. Appearance. S31 grade sugar. What report says? This set stock against the lab sample number so and so does not conform to the specification of S30 sugar as per IS standard. Then it was retested, Milord, because S31 is a higher category of sugar, Milord. They are at page, Milord, 104A, Milord. 104A.
Yes.
Remarks, serial number 3. S31 grade sugar is better than S30. And the requirements under the contract that either the milord S30 or above. So this is above, this is super quality of sugar. So these are all apparent high-handedness, milord, on the part of the government. And I have also demonstrated, milord, that even notice was issued without giving him even less than 24-hour times, milord. So how they have acted, milord? So this is a not only glaring instance of arbitrariness, but whole actions is infected with the vice of malafide, milord. And Article 14 of the Constitution is nothing but a duty to act fairly, justly, bona fide, and with a sense of responsibility.
Yes.
That's the requirement of Article 14. And that has been straightly violated, milord. And the Supreme Court catching of decisions has said, milord, that even in the field of contract, any state actions involve arbitrariness, the jurisdiction would be invoked, milord. That's the settled position of law, milord.
Yes.
Every actions must be structured, milord, with the non-arbitrariness, fairness, and bona fide, milord. So this initiations on inquiry and impositions of penalty is not violative of fundamental of right, is absolutely untenable. Then, milord, in support of his contentions, milord, learned Advocate General, milord, cited two decisions, milord.
Yeah, 1961 Supreme Court.
Yes.
And 64 Supreme Court.
Yes. Yes, milord. 61. Now, first I will rely, milord, 61. This is a case, milord, where the question of genuineness, milord, of the citizenship of a person, milord, was raised, milord, before the court, milord, under the Foreigners Act, milord. The questions before the court, milord, whether that particular person is a foreigner or not, milord. So, scheme of the act provides, milord, that when such allegations will be raised, milord, that the person who is claiming that he is not to be a foreigner, it is burden should be discharged by him to prove by evidence that he is not the foreigner, milord.
It is the burden of proof according to the Foreigners Act.
Absolutely. So therefore, court has says, milord, that without doing this, you cannot straightway come before the by invoking deed jurisdictions under Article 226, milord.
Yes.
So this is the facts is completely different, milord, and milord, every decisions, milord, that has to be taken to be accepted, milord, in the facts and backgrounds of the case, milord. A case law is an authority what is actually decide, milords, not what would flow from the logical deductions, milord.
Yes.
That's the settled positions of law. It's not a statute. And milord, in this case, milord, both the parties, milord, agreed, milord, to go for the suit. No one raised any objection. This is a concessional order. Then, milord, I invite your lordship's attention, milord, to the decision cited by learned Advocate General reported in 1964 Supreme Court.
Yes.
This is a case, milord. That the petitioner's, milord, he is a trader of jute, milord. He is having a place of business at West Bengal, milord, and place of business at Assam, milord. He purchased jute from various, milord, purchasers from in the Assam, milord, and then distributed to the various factory outside the Assam, milord. Then, milord, he submitted, milord, return of turnover, milord, for sale tax, milord, before the subordinate tax. Subordinate tax, milord, on receipt of those documents, milord, asks for the productions of the books of accounts in relation to the year of turnover, milord. But that was not produced, milord. Order passed ex parte. And scheme of the act says, milord, that there is a hierarchy of tribunal. First, milord, that the taxing authority who is having the power to decide the issue, my lord, whether the income is taxable or not, my lord. So therefore, that has to be decided by the inspector, my lord, superintendent tax, my lord. Then there is a provisions for appeal before the assistant commissioner, my lord. Then there is a provisions or appeal revisions before the commissioner, my lord. Then against the commissioner, my lord, there is a provisions for having a reference before the Honorable High Court only on the question of law, whether the order passed by the commissioner was bad or not. That will be decided only on question of law, not on fact. Fact has to be this fact-finding authority is the taxing authority. That is the superintendent tax, my lord. Here in this case, what happened, without making any reference to the High Court, what they have done, they filed a writ petitions challenging the findings of the taxing authority on fact, thereby reopening the case. That is not permissible under the scheme of the Act. Supreme Court says that the root jurisdictions cannot be invoked, my lord. And my lord, so my lord, that the Supreme Court, while saying this, my lord, came to a findings that there is no restriction in invoking root jurisdiction.
Yes.
And all these decisions, my lord, was, my lord, delivered, my lord, during the period 61-64, my lord. Then, my lord, that special, because the generally court may not entertain, but there is a special circumstances which has called out subsequently, my lord, in Walpole's case and followed by many other cases. So now this is settled positions of law. Here the case is that state actions absolutely involve arbitrariness and malafide, violative of Article 14, violative of fundamental right. So the jurisdictions could be amenable, my lord.
Yes.
So therefore, the petitioners invoke root jurisdiction, challenging the action, my lord, taken by the government, my lord, which is absolutely malafide and arbitrary. That was my case, my lord. আর কিছু আছে? And in addition to that, this is 1 minute. In addition to that, this was another limb of my argument, my lord, that the contract, my lord, says that a particular, my lord, requirement, that is 0.1, 0.10, my lord, should be the moisture content, my lord, in the sugar, my lord. But the Food Security Standard Act says, my lord, this should be 0.5. So therefore, my respectful submissions before this honorable court was that when statute says something and agreement says something, then statute shall override the agreement or the contract.
Statute shall prevail.
Yes, my lord. So that was my another limb of agreement, my lord. So I never disputed the report. I accepted the report. And on the basis of the report, I was allowed to distribute. I have distributed. The end consumers consume the goods. No loss suffered by the government. So that is my respectful submissions. That so therefore no loss was suffered. So this initiations of inquiry as well as impositions of penalty is absolutely arbitrary.
Yes.
And moreover, my lord, this resampling was allowed by them, my lord. And they did it, my lord. And they allow us to distribute. And that was, my lord, and that facts, my lord, was, my lord, apparent, my lord, from a communication which I have placed before your lordship. These are all in undisputed fact, my lord. So the factual submission made by the learned advocate general is completely, my lord, adheres to the facts, my lord, as well as the judgment, my lord, relied on, my lord, is absolutely untenable. And my lord, the one judgment I am relying, my lord, in Haryana versus Jagadamba Smith, judgment not necessary. This is a settled. This is a settled propositions of law. This is a rule of interpretations, my lord. How a judgment has to be interpreted.
Yes.
I invite your lordship's attention to a case reported in 2002 3 SCC 496, paragraph 19, my lord. Court should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decisions on which reliance is placed. Observations of courts are not to be read as Euclid's theorem nor as provisions of the statute. These observations must be read in the context in which they appear. Judgments of courts are not to be construed as statutes. To interpret words, phrase, and provisions of a statute, it may become necessary for judges to embark upon lengthy discussion, but the discussions is meant to explain and not to define. Judges interpret statutes, they do not interpret judgment. They interpret words of statutes. In so and so, paragraph 10 is not to be treated as if we are a statutory definition. It will require 20 is not necessary, my lord. Then paragraph 21. Circumstantial flexibility, one additional or different fact may make a world of difference between conclusions in two cases. Disposal of cases by blindly placing reliance on his decisions is not proper. The following words of Justice Hayatullah in the matter of applying precedents have become locus classicus. Each class depends on its own facts, and a close similarity between one case and another is not enough, because even a single significant detail may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide case, as said by Cardos, by matching the color of one case against the color of another. To decide, therefore, on which side of the line a case falls, the board resembles to another case is not at all decisive. Precedent should be followed only so far as it marks the path of justice, but you must cut the deadwood and trim off and side branches, else you will find yourself lost in thickets and branches. My plea is to keep the path of justice clear of obstructions which could impede it. So therefore, my lord, every judgment has to be decided, my lord, on the facts of the each case, my lord. And even a slightest difference, my lord, should make a world difference, my lord. So here the facts of the two cases are completely different and under the scheme of the act. So this is my respectful submission.
No, Lordship, there is no provision for reply of any reply.
Yes.
Only two things I will rely upon your Lordship. The report. Now, my learned senior advisory just now referred some resampling, report of some resampling.
Yes.
Now, if your Lordship kindly come to page 100, page 96 is the show cause notice. That when the sugar sample was tested and it was found not in conformity with the specification contained in the agreement and the tender document, this show cause notice was issued. Page 96, dated 12th October 2018.
Yes.
Now, along with the show cause notice, the testing report was forwarded to them. If your Lordship kindly come to the page 99, this is the reply of the writ petitioner against the show cause notice. Along with this reply, they annex the report. Lordship, kindly come to the last line of that particular page. After the signature of the proprietor, attached moisture lab report of the sugar stored at Dankuni from sugar manufacturer. So this particular report, which is appearing at page 100 and 100A, is the type copy that was not collected in presence of the representative of the corporation. It was the writ petitioner who tested the sample of the sugar at the manufacturing level that was relied upon. So this particular report cannot be relied upon.
Thereafter, resampling has been done.
Yes, Lord. That is permissible.
It's a prayer, my lord.
That resampling is permissible. The petitioners are to take precautionary measure. That measure was taken, and the quality of the sugar that was updated, and that will be reflected from the retesting report. So there was a gap from the date of supply of the sugar till resampling was done. And in the agreement, there is a provision that in case of first failure, the corporation is entitled to impose penalty. that penalty has been imposed. The question of using the goods, that will not stand in the way. Because since the goods has been consumed by the end users, the petitioner cannot claim benefit that since my goods has been utilized, you cannot deduct anything. The deduction, whatever has been made in terms of the agreement, because the agreement specified in case of first failure, the provisions are there for deduction of penalty. Following the provision, this penalty has been imposed. And the resampling that was done at a much later stage. It is not that entire amount has been deducted. Penalty in terms of the agreement has been imposed. So that is my humble submission.
Yes. That's all.
Yes, Lordship, so far the learned advocate general submitted that your Lordship will first decide the maintainability point. If it decided against us, then we will argue on merits of the case.
Very good. Please take down. During the course of argument, learned advocate general raised point of maintainability of the instant writ petition on the grounds that petitioner, being a successful tenderer, entered into an agreement with the government for supply of sugar. There are several clauses in the agreement. Among them, clause 13 is the arbitration clause. Learned advocate general further argued that it has been mentioned in the arbitration clause that if any dispute arises between the parties under this agreement, the parties may refer such dispute to the arbitrator for settle the same, for settlement of the same, full stop. Learned advocate general further argued that in this case, there is a dispute of supply of sugar by the petitioner, which is inferior quality. Full stop. Notice of show cause has been served upon the petitioner, which was replied by them. Learned Advocate General submits that the present petitioner submits that at the time of issuance of such show cause notice, one analytical report of sugar sample done by the inspection and quality control of the concerned department was annexed. In response to the show cause, the petitioner has also placed another report of other authority which was not authorized to take some authorized to inspect or submit a report according to the agreement. It is the contention of the learned advocate general that there are some disputed questions of fact. Rather, this court is not competent enough to assess which report is actually correct. That is the reason the matter should be forwarded to the arbitrator. It is the further argument of the learned advocate general that by issuance of show cause notice by the state authority upon the present petitioner, no fundamental right of the petitioner has been violated. Full stop. Petitioner has had every option to answer the show cause, thus had every option to answer the show cause, thus the instant writ petition is not maintained. Full stop. In support of his contention, learned advocate general has cited two decisions reported in two decisions. One karo Union of India and others versus Ghaus Muhammad, H-A-U-S, Ghaus Muhammad, reported in 1961 SCC online, SC2. Second, देखो Than Singh Nathmal versus Superintendent of Taxes, reported in 1964 SCC online, SC13. There. Learned counsel appearing on behalf of the petitioner. No. As the point of maintainability has been raised by the learned advocate general before initiation of the entire matter on merit, this court thinks it necessary to dispose of the point of maintainability as raised by the learned advocate general at its inception. Next para, learned advocate appearing on behalf of the petitioner submits that the show cause notice issued by the respondent authority itself arbitrary. The show cause notice was served on 12th of October 2018 and they directed the petitioner to answer reply within 24 hours, within less than 24 hours, that is by 13th of October 2018. This shows the arbitrary action of the respondent authority. He further submits that the alleged show cause notice containing the analytical report of sugar sample was on the prayer of the petitioner, no, on the representation of the petitioner, retested and resampling report was placed with this read petition, wherefrom it would be appear that the said resampling was done by the same authority, which shows the moisture content of sugar was within the permissible limit. It further submits that in respect of each show cause notices, there are every resampling report which shows that the sugar that the moisture containing sugar is within the permissible limit. Learned counsel for the petitioner further argued that the agreement admittedly may have some arbitration clause, but when the arbitrary action of the respondent authority was alleged by a petitioner, this court as well as the Supreme Court has time and again decided the issue that when violations of an act is under challenge, or when there is allegation of violation of fundamental right of any petitioner, the matter should be within the ambit of the High Court under Article 226 of the Constitution of India. It further submits that the decision relied by the Honorable Learned Advocate General is of other perspective of facts, and they are all distinguishable. They also placed reliance upon a decision of Honorable Apex Court reported in Haryana Financial Corporation and another versus Jagadamba Oil Mills and another, reported in within bracket 2002, 3 SCC 496. To substantiate the plea, to substantiate the principle that decision of the court should be dealt with upon the factual situation of each cases. In the said decision, the Honorable Apex Court has held that paragraph 21 within bracket, comma, circumstantial flexibility, comma, one additional or different facts may make a world of difference between conclusions in two cases. Full stop. Disposal of cases by blindly placing reliance on a decision is not proper. Full stop. Having heard the learned counsel for the parties, in reply, it was submitted on behalf of the state authority that resampling might have done by the same testing agency of the government of West Bengal, but it would be revealed that the sugar sample which was collected at the time of issuance of show cause notice and the resampling was done much after that. The petitioner was penalty was imposed upon the petitioner for first offense. Thus, there is no arbitrary action on the part of the respondent authority. Full stop. Having heard the learned counsel for the parties, it appears that the learned Advocate General has raised the issue that when there is an alternative remedy available to the petitioner must exhaust the remedy. Full stop. In this particular case, it is the contention of the learned Advocate General that the arbitration clause has itself agreed between the parties that that if there is any dispute, the matter shall be referred to the arbitrator. Full stop. Let me consider the issue properly. Full stop. In this particular case, penalty imposed upon the petitioner by the respondent authority on the allegation of supplying of sugar containing more moisture than the permissible limit is under question. Full stop. In this case, the action of the authority regarding service of prompt show cause notice and asking reply within 24 hours is a issue. Moreover, the petitioner has also challenged by showing the provisions of the agreement that standard of sugar should be maintained according to the provisions of norms of Bureau of Indian Standard, but in the instant case, the respondent authority has specified the standard according to their wish. Full stop. It has been argued specifically by the learned Advocate General that the difference between the two reports cannot be properly assessed by this court. For that reason, the matter should be referred to the arbitrator. Full stop. Considering the entire issue involved in this writ petition, also considering the observation of Honorable Apex Court, preferably in Whirlpool Corporation Limited, it has been specifically laid down that where there is an allegation of violation of fundamental right by an individual, or where there is where violations of act has been is under challenge, a writ petition is maintained. Under the above observation, it appears to me that the writ petition and issues thereof does not merely contain about the reports and their findings thereof. There are some other merits to be determined which were challenged by the present petitioner on hearing on merit of this matter. Thus, in my view, the instant writ petition is amenable to the writ jurisdiction. The argument on behalf of the learned advocate and argument on behalf by the learned Advocate General is considered to me not meritorious at this stage. Let the argument, the argument on behalf of the parties had already been completed. The state authority, the argument of the petitioner has already been concluded. The state is directed, state respondent is directed to submit on merit submit on merit. Let the matter appear in the list for argument on behalf of the state respondent on July 23rd. July 23rd, 2025. Next.
Good. Good.
Item number 4, I'm for the petitioner. Learned advocate Mr. Ramanand Agarwala, who is appeared in this matter, he is not prepared today for this matter. Your Lordship kindly takes the matter at any day after returning from circuit bench.
An accommodation short order on behalf of the petitioner, let the matter be urgent to release the matter. July 18. Sorry, July 28. July 28. July 28 at 2 p.m. Next.
My lord, your lordship is taking up matters, my lord. I know, my lord, but since Mr. Shahara is here, with your lordship's, my lord, leave, may I point something out which I had discovered during the weekend. My lord, just before the weekend, my lord was pleased to take up a matter in which Mr. Shahara and his chambers were appearing. Now, my lord, on my submission, an order has been passed and they were not given any interim order. My lord will kindly recall the order was to add the grantee of the license as a party. Now, my lord, I find that, my lord, this order has been passed by your lordship on the, my lord, perception that license has been issued. However, my lord, why I mention this before your lordship for your lordship's consideration is the instructions were that, my lord, offer letter has been issued and money has been deposited. My lord, my instruction never said that the license has been issued. I have re-verified license thereafter has not been issued. The matter was supposed to appear today, it did not for some reason, my lord. I thought it prudent not to keep it waiting. I had informed Mr. Shahara. My lord, I thought
tomorrow.
yes. I thought, my lord, I should inform your lordships also.
Which was our
number?
My lord, this is the order, my lord.
It will appear tomorrow. Wrongly not appear.
Some lapse, my lord, it did not appear.
It may happen, man. It was wrongly recorded 23rd
Yes.
July, as I understood.
Yes.
That may be the reason. It may be corrected tomorrow, my lord. Let it appear as to be mentioned tomorrow.
June is the order. আপনারা ভুল শুনেছেন? ও ঠিক আছে কালকে।
Lord, my apologies, my lord, to disturb the court, my lord, but I thought it prudent to bring it to your lordship.
Tomorrow, your lordship will point it.
Great. Thank you, sir.
Item number, my lord, 5, my lord, is a matter, my lord, which is tagged with the rest of, my lord, some almost a dozen matters. My lord, this is, my lord, recalls, my lord, this is regarding those, my lord, trucks which were confiscated.
Okay.
And my lord, I'm led by Mr. Sengupta. My lord, I understand Mr. Sahara is appearing for some of the petitioners, not all of them are here. My lord, anyway, I do not think, my lord,
Sagar
Bandyopadhyay was appearing for some parties. My lord, kindly, my lord, keep it someday, my lord. Time লাগবে তোমার হবে না না
whether we have started argument on
Yes,
this.
yes.
My lord, I'll apprise your lordship. My lord, what happened was, my lord, the initial argument was made from the behalf of the state, my lord, regarding the maintainability of the writ petition.
Yes, and it was
Then after, my lord, exchange of arguments, my lord, lordship was pleased to decide the point of maintainability. Now, my lord, the merits would be heard. My lord,
whether Mr. Bandyopadhyay is
coming. Mr. Bandyopadhyay is not
Started
yet here,
argument
my lord.
on merit.
Today, my lord, we are also awaiting some instructions on this. My lord,
We shall continue. It will not conclude today. Let him take instruction. It will continue. It's a big matter.
What you want?
My lord keeps another, my lord fixes a date.
Let me conclude.
Because, my lord, there are
Because
so many matters, my lord, because, and the other learned advocates are also there. Everybody, my lord, ultimately, my lord, it will be one issue. So, my lord, everyone, my lord, turn by turn, my lord, will they make their arguments. In the presence of everyone, it is, my lord, in the fitness of things. That's all I am submitting.
Let me continue, my lord, because our argument will not be concluded today itself. So, your lordship have to fix the matter after your lordship returning back from
Yes,
the
let us start then.
Well, because otherwise, my lord, it will be a piecemeal manner. Because perhaps it is better to fix it on a day.
What is the difficulty? No.
Okay, Mr. Bandyopadhyay, start.
Yes, start.
Let him start first.
Very well.
Since I am not there for 15 days, not necessary to worry about that. Yes, let's start this.
You know.
Yeah.
My lord, in fact, my lord, there is a well, the instructions which are coming, but there's a possibility of an appeal also. Well, that is why in the my lord, I had made this submission. Maybe it can be kept, my lord, after lordship comes back. In the meantime, my lord, all the steps. Otherwise, my lord, I leave it to your lordship. My lord. I cannot, my lord, say anything.
But in fact, the argument I had already started on the last occasions. It has been
I
made.
thought the argument has concluded.
Yes, no, that was in respect of the maintenance.
No, no, that is not the issue. Thereafter, you have started argument.
I had just started, but not completed. I had just placed the facts, my lord.
Yes.
Yes.
Okay, start it.
Yes. Now, again, I just remind your lordship most probably recollect that there are the exports, wheat meant for exports, which were initially detained by the customs authority. They said that since there is some bags, there is reference of government of Haryana and FCI marks, etc. So they anticipated that this may be a wheat, diverted wheat. They referred the matter to the police. Now the police, on the basis of their reference, straightway registered an FIR. FIR was registered on 23rd of October 2020. I had handed up probably this list of dates. If you will see.
আমাদের এখানে কপি দেবে
কোথায় রে? ফাইলে নেই।
লিস্ট অফ ডেট দিছিল কোথায়? লিস্ট অফ ডেট
দরকার নেই, ওইটাই দে। Got it.
Not that.
The list of dates.
Give me a copy.
In Swapon Ray's matter,
In which matter you have given it to me?
Item number 5.
Only 5.
In which matter?
Item number 5, Swapon Ray. First matter. You also had taken the first matter.
কপি দেবে দাদা
ঠিক হ্যাঁ আছে তো স্বপন রায়, এটা তো অন্য ম্যাটার আছে, দেখুন পরেরটা দেখুন। Okay, you proceed.
Well, I'm giving another copy.
Yes, yes. দাদা
পরে দিচ্ছি দাঁড়া।
হ্যাঁ আমাদের দাও যাই করছো
That first,
May we get a copy of that list of dates?
Yes.
On 21st October 2020, the wheat was purchased. It was placed. It was waiting for the shipping bills were placed before the custom authority for processing. While these were waiting at Ghojadaga border, the customs detained. You also had seen it. Kindly straightway come to page . page 50.
Yes.
Page 50, the Deputy Commissioner, my lord, what she says, my lord, kindly take, my lord, paragraph 2. The marks and numbers of the jute bags containing which are Government of Haryana mark, Punjab Sarkar, Government of West Bengal. The 5 photographs of the sample jute bags intercepted are enclosed for reference. Preliminary inquiry with the policy 3 wing in the Department of Food and Supply, such and such, have confirmed that jute bags containing such marks and numbers are only to be used for which meant for PDS. No private person is permitted to use such jute bags. Well, this is totally wrong. This is the extent that to prevent diversion of PDS, it is stipulated that if such bags are no longer usable by the any state FCI, these are openly available in the market to hide the mischief, the unscrupulous person, such and such, then he forwards the customs officers to disturb the wheat bags and reserve them to detect the state government marks and numbers on the reverse side. The intelligence about the diversion of PDS is corroborated by the fact that declared export price per quintal is marginally less than minimum support price of MSP. Never it was disclosed what is the minimum support price. Now, the list of trucks which have been detained by the customs is enclosed. You may also make necessary security arrangement immediately to prevent any pilferage, substitution of the wheat loaded trucks. This was forwarded first, my lord, on 22nd of October 2020. Next page, on page 52. Another communications dated 23rd October 2020, by which, my lord, the handing over of the case for investigation to the officer in charge, Bosirat PS. Now, kindly take, my lord, last paragraph of page 52. What allows to hide the mischief, unscrupulous persons, restuff the bags and reverse the empty bags, which was reflected again the marks, numbers showing state government name, etc. on the inside of the bag of the filled bags and are not visible on the outer surface. Due to Puja vacation, port is closed till 27th of October 2020. As a result, all drivers, Khalasi and CF have left Gojadanga area. It has not been possible at this moment to check the contents of the truck properly by opening the cover and markings and absence of proper person. However, 4 bags have been brought with marking of various state indicating there is possibility of diversion of PDS, which these are the observation of the customs.
Yes.
Are handed over. Only shipping bills along with the export invoices have been uploaded in the EDI system. This is the prevalence system for processing the export. EDI system by the exporters, we are enclosed with the name of the exporters, customs brokers from our system and other documents like purchase invoice, track numbers and corresponding invoices by the exporters. Wherever these documents will be submitted by the exporter CNF agent, this will be forwarded to your action. This was straightway treated as FIR 63. The FIR was registered on 23rd October 2020. Kindly take serial number 13. It was initially registered, for commission of offence under section 379, 411, 413, 414 and 120B of the IPC. As well also got page 63, serial number 13.
Yes.
Page 65, after this, all the petitioners were asked to produce the relevant documents before the sub-inspector police. These were subsequently complied with. Now, the first seizure list you also will find at page 66. Kindly mark it, Mala. This will be relevant in course of our argument also. Page 66 is the only seizure list provided to the exporters, all exporters. Other than the, no other seizures pertaining to the wheat. The other seizure list, when we produce the documents, those were marked and a separate seizure list was prepared individually. This is the only seizure list which was handed over to the exporter. Now kindly take page 66, serial number 5. 4 jute bags containing wheat, approx 50 kgs in each bag. The said jute bags having marking of the Food Corporation of India in blue ink. The above noted article are in packed condition seized as alamat in this case. Has you got it? Serial number 5, description of the article seized.
Yes.
Page 66. So only 4 bags, that seizure list was given to all the exporters, including the present petitioner. Now, page 67.
Forwarding.
A prayer was made before the Court of Learned Additional Chief Judicial Magistrate by Sub-Inspector of Police. Last but one paragraph.
Yes.
Hence, under the above circumstances, I am praying before your kind honor that necessary direction may kindly be given to appropriate authority under Essential Commodities Act 1955 of the Government of West Bengal and to confiscate the detained huge quantity of wheat as per extant law for taking Jimma after counting and inspection of those huge quantities of wheat loaded in the trucks which were detained in CW above. Now, pausing here for a moment, when this prayer was made, by that time, no provision, the section 7(1) AII was not added. There was no case under the Essential Commodities Act. The SI asked for a directions upon the appropriate authority to confiscate. But surprisingly, the same magistrate also gave that directions. Now, page 68 on 20. This was made on 24th of October. Now, page 68 on 25th of October. Now, prayer for addition of section 7(1) AII was made. Page 68. Last but one paragraph after 5 lines. Down. Well, kindly take on 24th, as you have got it from bottom 10 lines. On 24th October 2020, I also submitted prayer before your learned court for passing necessary order to give directions to the appropriate authority of Government of West Bengal to confiscate the detained huge quantity of wheat as per extant law for taking Jimma after counting and inspection of those huge quantities of wheat loaded in the trucks which were detained in CW above noted case, and said prayer was considered. In course of the investigation, it revealed the goods in questions are related to PDS. Hence, section 7(1) AII of the Essential Commodities Act attracts in this case. I have also received observation from the Deputy Inspector General of Police Enforcement Branch, West Bengal, for including the appropriate section of the for further investigation of this case. Considering the above circumstances, now this prayer was made. And subsequently it was also allowed and 71AII added, and pursuant to the directions of my lord magistrate, the goods were also, the wheat were initially also confiscated.
Yes.
The page 70, these are the seizure list, my lord, given to all exporters who had produced documents, my lord, claiming the ownership and the, my lord, their licit ownership and the documents, my lord, related to exports. Both purchase and exports, my lord, those were, my lord, seized, and a seizure list was prepared. You also will not find, my lord, there is no mention of any, my lord, wheat or wheat bag in this seizure list.
Yes.
Now, in the petitioner, present petitioner and others also moved before this High Court, filing a writ petition challenging the entire process. Page 74, the order starts. I'll just show page 76.
Yes, proceed.
Page 76, my lord, middle portion, by an order dated 25th October. Has the lordship got it?
Yes.
By an order dated, page 76, after 10 lines, by an order dated 25th October. By an order dated 25th October 2020, the learned additional Chief Judicial Magistrate SAM allowed such addition of sections and also allowed an application submitted by the investigation officer praying for issuance of directions towards confiscation of the detained goods. The orders had been brought on record by supplementary affidavit. Let the same be kept on record. A memo dated 11th November 2020 has also been placed before the court, by which the petitioners were intimated that the stock of wheat had been confiscated pursuant to the order dated 24th October 2020. No proceeding for confiscations, no notice, straightway confiscated. That was the first round. Malad, there is no relief was granted by the learned single judge. Malad, the interim order was not. Only directions for affidavits were given. Malad, against that, an appeals were preferred before the division bench. Order starts at page 81. The judgment delivered on 10th of December 2020. Start from page 81, page 82, the narrations first.
Yes.
After quoting relevant provisions of the Essential Commodities Act, paragraph 16, page 90, an order of confiscation by itself under the EC Act is momentous and deprives the citizen of his right to property. A plain reading of the aforesaid provision makes it clear that before an order of confiscation is passed, the collector must, A, B, C, D, F. These are the conditions have been enumerated by the division bench itself in the judgment. Now, 17, the order of confiscation, my lord, which was produced before the single bench. My lord, the facts of the case in hand that reveal that the order of confiscation was passed by the relevant officer mechanically only to comply with the order of learned magistrate, and in passing the order of confiscation, the authority did not follow any of the statutory requirements as indicated above. Such order of confiscation passed in violations of the statutory requirements deserve to be interfered with in exercise of jurisdiction, notwithstanding the statutory remedy of appeal available to the appellants. Then, my lord, 18. My lord, 18 is relevant. My lord, I'm just reading. If any persons contravenes any order, my lord, when this confiscation arises, if any person contravenes any order made under Section 3, the investigating agency may prosecute him under Section 7 of the SC Act before the competent criminal court, and the property in respect of which the order has been contravened may be forfeited by the government. The order of the Satan subsection 1. Now, subsection 1 of Section 6A requires an investigator to report to the collector without any unreasonable delay as to the seizure made under the EC Act and seizure made under the EC Act. Kindly take a note. And upon such report being made, concerned collector may initiate a confiscation proceeding if he is satisfied as to the violation of the order passed under Section 3 of the EC Act. An order of forfeiture is a judicial order passed by a competent criminal court upon proving guilt, while confiscation is an administrative action to be undertaken by the collector. Both the proceedings may run simultaneously. It was therefore wholly unnecessary for the investigation agency to approach the learned magistrate for confiscation of the goods at the investigation stage. It was equally inapposite for the learned magistrate to direct the state to confiscate the goods. Now, after this, my lord, page 93, paragraph 22. Paragraph 22, the order of confiscation was set aside. It was remitted back to the collector to initiate proceedings as per the guidelines, my lord, as per the conditions, my lord, enumerated in the paragraph following this, my lord, requirement, paragraph 16.
Yes.
The writ was finally, my lord, it was remitted back. The writ was, since writ was kept pending, it appeared subsequently, my lord, page 96. I just show, but because our another prayer was for confiscation of the criminal case, for quashing of the criminal case. My lord, that the learned single judge, my lord, said that since this prayer was not allowed by the division bench, so no such relief can be granted at that stage. Page 96. It was disposed of, my lord, without passing any further order. Page 107, paragraph 22. Paragraph 22, my lord, kindly take the division bench has given liberty to the state to initiate fresh confiscation proceedings that are to be included, that are to be concluded within a period of 8 weeks. In parting, this court also directs the state authority to ensure that the goods that have been seized are kept in a secured manner as directed by the division bench. I make it clear that in the event the goods are detained without having been seized or detained as per law, the state authority shall not create any impediment and shall release the same forthwith.
Yes.
Thereafter, my lord, the fresh notices, purported notices under Section 6B of the Essential Commodities Act was issued by page 109.
Yes.
Now, before your lordships consider this show cause, I just refer the relevant provisions.
Yes.
Now, first, your lordship kindly take section 7. This is the offense. Penalties. Page 24 of that book. As you lordship.
Yes.
Now, if any person contravenes any order made under section 3. As you lordship.
Yes.
If any person contravenes any order made under section 3, he shall be punishable in case of an order made with reference to clause H or clause I of subsection 2 of that section with imprisonment for a term which may extend to 1 year. In case of any other order with imprisonment for a term which shall not be less than 3 months but which may extend to 7 years. Provided that the court may, for any adequate or special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term not less than 3 months. But you are concerned with 7(1)(a)(ii) only, because if the control order your lordship is aware from section 3.
Yes.
Kindly take section 3. Then your lordship will see the difference between AI and AII. Kindly come to section 3 at page 7 of that book. The powers to control production, supply, distribution, etc. of the essential commodities. Now, if the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing the supplies of an essential commodity or for securing their equitable distribution and availability at the fair price, or for securing any essential commodity for the defense of India or the efficient conduct of military operations, it may by order provide for regulating, prohibiting the production and supply, distribution thereof, trade in and commerce therein. Now, 1A, notwithstanding anything contained in subsection 1, these are the provisions. Now, kindly take subsection 2. Without prejudice to the generality of the powers conferred by subsection 1, an order made thereunder may provide. Now, these are the A, B, C, D, E, F, G, H. Now, kindly come back to section 7. If clause H or clause I of subsection 2, then imprisonment is 1 year, and for other clauses, it will be up to 7 years. Clause H, you also will get it. Page 9, for collecting any information or statistic with a view to regulating or prohibiting any of the aforesaid matters, and I is for requiring persons engaged. Now, I is, you also will get it. Baba. I for requiring person engaged in the production, supply, or distribution, or trade, or commerce, or in essential to maintain and produce or inspection such books of accounts record, alleging the business to furnish such information relating thereto as may be specified in the order. Or if any violations relates to these clauses, my lord, any control order issued in respect of these clauses, the punishment is 1 year. If my eyes, my lord, do not betray, DEFEHI. And for other clauses, my lord, the punishment is, my lord, for 7 years. If any control order pertains to other clauses, my lord, it will be 7 years. Am I clear?
Yes.
Now, now comes confiscation. My lord, section 6A first.
Mr. Bandyopadhyay, today we are out
Yes,
of time.
my lord, I will ask you kindly, we may continue.
Yeah,
My lord, interim order needs to be extended. Last year, last we extended till 30th June. Last.
Argument on behalf of the petitioner continuing. Matter made part heard. Let the matter appear in the list on 29th of July 2025 at 2 p.m. on the same heading.
29 July. Lordship is keeping
29th.
15 July, another matter, you also fixed my another matter.
15th July, no, first week, after returning, first week, second week are the busy weeks. This is the third week. Let it be there. Interim order passed by this court on the earlier occasion is further extended till 22nd of August 2025 or until further whichever is earlier. Yes.
My lord, will the other matters, my lord, lordship is passing separate orders in the matters.
Same orders.
Same order, but separately.
Sorry. What you want? Separate order?
My lord, and I believe, my lord, those are the two affidavits in opposition, my lord, that my learned friend is submitting with regard to item 7 and 14.
You serve the copy. You serve the copy through the learned advocate appearing on behalf of the petitioner. Do you note? Item number 8 and
14 is I am happy.
you serve copy. তাহলে কি অর্ডারটা সেপারেট করে দাও সবগুলো I want the name of the learned advocate. You give me the names.
Yes.
To my officer so that the order can be passed.
Immediate. Yes. I'm great.
Item number 8 and item number 13. Affidavit in opposition on behalf of the respondent number 4 is taken on record. Order.
Grateful to you.
পয়সা পাবে না দিয়ে দাও ওকে থ্যাংক ইউ
আসল টাইমে থাকতে পারলাম না
আর বাইকে order extended.